But may I beseech your lordships to mention one matter for non-prosecution, habeas corpus matter for non-prosecution.
My lord, matter related habeas corpus. Opposite,
New matter or it was heard earlier?
not new matter.
It was heard earlier, please give a notice and mention. Give a notice to your other side and mention.
Lordship,
Yes.
Lordship, this is a habeas corpus matter, Lordship.
Mention today.
Yes.
You have given the notice, you'll mention today.
Yes,
Then,
yes.
you know.
Lordship, this is a habeas corpus matter, Lordship. I shall give notice, Lordship. Lordship, the lady who has gone missing is a family member of our legal fraternity, Lordship. This matter was heard earlier, Lordship, and wide order dated 26th of February 2025. Honorable Justice Urjit Banerjee and Honorable Justice Apurva Sinha Roy were pleased to direct that the matter shall appear on 26th of March.
Very good, madam. Are you mentioning upon notice?
Lordship, I shall
Where
mention.
is the notice?
Lordship, today only I shall mention. I shall give
Give a
notice.
notice and mention on Monday.
Wait for my
Our order. We just, my brother, order passed by myself. Fresh note, new
Application group 6.
new application.
Lordship, the matters pertaining to the control order 2013, Lordship, that several matters will be heard by your Lordship by today itself. My matter is also similarly placed, Lordship. It was earlier placed before the Honorable Justice Joymanlo Bakshi, and subsequently I mentioned before
So
the
matter is being
assigned
heard
before your Lordship. I checked.
Assigned?
Yes, your Lordship. Those are assigned before your Lordship. There are 3 matters, Lordship, and all the analogous matters will be taken up by your Lordship by today itself at 2 p.m. Lordship.
So, but today it cannot be placed.
Lordship may be placed on the in alternative day, Lordship. I will come and indicate
It
at
is
2.
finished. What we will do?
All are the similar matter, Lordship. I am also affected by the order. Similar times those matter was heard and same order has been
You are
passed.
not understanding what we are saying.
Lordship.
Today, you should have mentioned it earlier. We could have
Earlier I have mentioned Lordship, but it was not assigned. But subsequently it has assigned before your Lordship.
নিয়ে নাও যদি আজকে।
And file is also come before your Lordship.
May I be permitted to
Grateful to you.
mention, Milord, I am seeking leave to file without the certified copy, Milord, and to move tomorrow, Milord.
Why?
Milord,
What is
the
the
interview,
order? When was the order passed?
Milord, on the 22nd of April.
You have applied for certificate?
Milord, applied subsequently, Milord, not received yet, Milord, and not received the certified copy yet, Milord.
File
Today,
it will appear after.
Milord,
58
the only difficulty is, Milord, today is the interview, Milord. If I am not heard tomorrow, Milord, then the appeal shall become infructuous, Milord.
Who was your other side?
Milord, Union of India, Milord. I shall intimate, Milord, if your Lordship.
If you can bring, it will happen. Otherwise,
Milord,
without
tomorrow
service, it cannot.
leave be granted.
What is the order passed?
Milord, the order passed, Milord. The fact is that,
We are not on fact. What is the order passed?
Milord, the order is that the writ has been dismissed, Milord, and
Then what is the
subsequent.
urgency?
Milord, the urgency is today is the interview process, Milord. I will not get promotion if I do not apply. Milord, on
দিয়ে রাখো লিস্টে দাও। Give a notice to your
Yes.
other side. File it and give the number.
I shall, Milord.
If
Get
দিয়ে দাও।
Lordship, may I be permitted to mention
Yes,
before your
Mr.
Lordship?
Milord, I have a very one request, yes. But at 2 o'clock, if matter is there, it's all right. Milord, I need 15 minutes accommodation, Milord, only that. I will come by 2:15 or 2:20. Kindly just excuse me for that, Milord.
All right.
Just is it.
All right, Mr. Baldwin. এটা মনে রেখো শোয়া দুটোই দেখতে হবে।
Lordship, may I permitted, my Lord, this is a restoration application, my Lord, for the group
Are
6.
you mentioning upon notice
Yes, my Lord, I am. My Lord.
that you will mention today?
Yes, my Lord, I am mentioning.
My lord, one habeas corpus matter.
Lordship.
New matter,
New matter.
not heard earlier.
One appeal, your lordship, for inclusion in the list. New matter.
What?
Appeal for
Appeal of which year?
2021.
21
Raising of-
file. Paper books filed.
Everything has been filed. Memo of appeal has been filed. Stay has been filed.
Where you are mentioning our notice?
Yes.
নিয়ে নাও combined listed the other. Yes.
May we permit to mention one habeas corpus matter? This was heard by the other coordinate
Where is
bench.
your notice, Mr. Shawar? Give a notice
it
and
was
tell us
met-
on Monday.
Good.
Yes.
My lord, may I be permitted to mention item number 13 of day's list for upgradation? The urgency is the
Yeah.
appeal will become
Item number 13, it will be reached. Don't worry. Yes, call the list. আচ্ছা, কার্তিক কালকের লিস্টে 6 নম্বর ম্যাটার ছিল, শীর্ষান্নর রাউন্ডে।
In addition to an earlier argument, my lord, Lord, kindly come to page 20 of the running page 20 of paragraph 13. This is my lord's observation in contempt application.
Page 20.
Page 20, running page 20, paragraph 13 of the order, my lord. That there is observation of this division bench, my lord.
Page 20 of the order.
Contempt, no, page, contempt petition, page 20, running page 20.
Yes.
Paragraph 13, my lord, I am reading, my lord. In view of the above procedure, this is adopted by the respondents. The petitioner, on being successful in LDC, was only promoted and not directly recruited. Hence, the petitioner is entitled to the entire service rendered by him from the initial appointment for all the benefits, including MECP. The petitioner entire service of 32 hours taken into account on his retirement for calculating pension. And this is my lord observation, and direction is, my lord, page 21, paragraph 17. So the issue has to be decided, my lord, whether the training period will be excluded or included for purpose of MECP.
Mr. Judge, how can we do that in the contempt application?
But my lord, directed that entire period may be taken into an account for the third MSCP. They have the issue. They have been, my lord, now agitated, my lord, now, my lord, introduced, my lord. That is not the issue, my lord. They have newly that issue has been cropped up, my lord. Because of that can be my lord, kindly see their MSCP circular, third MSCP from the date of initial appointment. Their own circular.
Yes, that is at page.
Not another two circular I am relied upon, which is the Southern Railway sought for clarification to the Railway Board, my lord, for purpose.
এটা খুলে দাও না, খুলে দাও।
Kindly see the read petition, page 70, my lord. Everything will be clear, my lord. Page 70. Read petition, page 70, my lord. When I made a representation to the authority for calculation or for purpose of my MSCP, they have sought clarification to the railway board. My lord, their entire details they have been here, my lord, written, my lord, page 770.
Yes, page.
Page 70 of the read petition, my lord. When I tendered my representation to the authority, my lord, they are sought for clarification to the railway board, my lord, dated, my lord, 28/7/2015, my lord.
Page.
Page 70 of the read petition. Issued by Deputy Chief Personnel Officer to the Deputy Director Pay Commission, Ministry of Railways, for clarification. I was made an allegation that my batchmate were also grant MSCP from the date of appointment, my lord. My lord, kindly see paragraph A, my lord. Sri Ashok Sengupta was initially appointed as apprentice PWI grade 3 on 1/9/1983 in pay scale rupees. My lord, kindly note it, pay scale rupees 425 and 700 in fifth pay scale, corresponding to grade pay 4,200 in pay band 2 and 6 CPC pay scale. He joined in the working post 23/3/1984 after due curtailment of the prescribed training period of 1 year due to shortage of PWI at
You joined on 23rd March 84.
I was appointed 1/9/83. Thereafter, I was sought for, I have sent for training. Thereafter, I have joined after 6 months.
So that period they are excluding.
That period they are excluding. Thereafter, my last paragraph, this is very paragraph E. As regards the grievance of Sri Sengupta for extending the same benefit that of third MSCP as was given to his batchmates, Sri Tapan Bose, Haradhan Mukherjee, Gautam Choudhury, Parashottam Ghoshal, Madhusudan বিশ্বাস, Prabhakar Mondal, whose date of appointment is the same that of him. It may please be noted that unlike Sri Sengupta, they are promoted to that is not relevant section engineer, so corresponding to gateway against the promotional vacancy, remaining 80% of the promotional quota in order of their respective seniority. As such, they are entitled for grant of third financial upgradation on completion of 30, this is the typing is 30 years of service from the date of their initial appointment in the entry gate as per policing. My batchmates are given 30 years from the date of initial appointment. My case, they have excluded the 6 months.
And where is the MSCP circular? you
MSCP
showed?
circular, my lord, the
Page
Southern Railway sought for
150.
clarification whether training period will be included or not. But Railway Board order my lord, already handed over. My lord, kindly see the second
The
page,
first come to page 115.
115.
They are saying it is thus evident first financial upgradation would
Yes,
be
yes,
added
sure.
10 years of regular service.
That is, I have loose paper, I have, that is annex, my lord.
Annex what?
Yes, that is annex. That is the Railway Board order. I have annex. First page, my lord, skip, my lord, this is the Southern Railway circulated. My lord, second page, order dated 27/6/2014, issued by the Railway Board. My lord, I am erroneous implementation of MSCP scheme on railways. This is the subject. They have communicated to all general managers of all zones. It has been brought to the notice of the board's office through its vigilance department that on some of railways, third financial upgradation under MSCP schemes being allowed on completion of 20 years of service on first promotion, considering deemed second MSCP of the concerned employee well before 1/9/2008, as the MSCP scheme has come into effect from 1/9/2008, only such an assumption in bloodline for this is not relevant in my case in second paragraph. In this regard, attention is invited up to board's letter event number dated 29/12/2011, that is on the next page, whereby it has been categorically clarified that third financial upgradation is admissible either on completion of 30 years of service from the date of initial appointment or further 10 years from the date of second financial upgradation stroke promotion, whichever is earlier. It is therefore emphasized that the instruction communicated by his board's letter dated 29/12/2011 may please strictly adhere as any deviation therefore may attract vigilance action. Further, the next page is the 29/12/2011, the Railway Board circular. Last but second paragraph, this is important. Further, the illustration under para 28 also demonstrate that the first financial year upgradation would be
From the
admissible.
date of actual joining.
Oh, that is one of the second page.
Yes.
Date
Second,
of initial appointment.
no, last 29 December 2011.
29 December 2011, my lord. Second,
That says,
last paragraph, the second paragraph, my lord.
yes,
Further, the illustration under para 28 also demonstrates that first financial upgradation would be admissible on completion of 10 years of service from the date of actual upgradation. I am not claiming that is first MSCP. And this is first
so
MSCP.
first MSCP will flow, na? Your period of service.
Thereafter, my lord, kindly go through, my lord, thereafter. Posting the entry gate. That is, I am not disputing. Second financial upgradation on completion of 20 years of service from the date of initial appointment. What that appointment I have earned, my lord, the pay scale, my lord. I have earned increment on that date, but only some allowance I have not been get at the time of training. My lord, thereafter, my lord. Whichever is allowed. And the third financial upgradation would be admissible on completion of 30 years of service from the date of initial appointment. There is no ambiguity that the training period will be excluded or included. Date of initial appointment is 1983, my lord. It is my submission, my lord. And my lord, original Railway Board order, SLP has been dismissed. Thereafter, they have sought for clarification because the Zonal Railway not the authority to implement. Railway Board had issued an order, thereafter Zonal Railway implement. But the original Railway Board order, till date, they have not disclosed in the affidavit. That is my
Original railway.
Railway Board direction that the order may be implemented. In my case,
Where is that page?
yes, my that matter they have till date they have not disclosed before my lord.
So you are meaning to say
Kindly
that,
see their affidavit.
no, you are meaning to say that in spite of Railway Board affirming in your favor, the zonal has acted.
Zonal, yes, this is my submission. Let them produce the original Railway Board order. They have stated the amendment, but copy is not annexed. That as I have annexed in the supplementary affidavit.
Supplementary?
Yes, one supplementary affidavit I have
The
filed.
affidavit in opposition.
Yes,
contempt.
that is in contempt. I file and reply, affidavit in reply. They have filed opposition, I filed reply.
So
Reply, kindly see the page R1, page
reply
6.
is filed by you.
I.
Their affidavit, you say that they refer.
They are reply, they have kindly see their my reply R1 6 page 6.
Yes.
In terms of the Railway Board letter dated 10/9/2024, the following retired sub of the Principal Chief Engineer Office Eastern Railway has been found suitable by the duly constituted screening committee for that order they have not disclosed. Let them produce that order. 10/9/2024. For the Railway Board said the period of training will be excluded.
If total has been found suitable in terms of 10th of June, as clarified on 10th of December.
That is Alada, sir. That is RBE action. That is I have already annexed in the writ petition. That is RBE number. But it just did this letter, 10/9/2024, after SLP dismissal of SLP, this Railway Board order they have not disclosed, my lord. In my case, my lord, this is.
Yes, what do you say?
Firstly, my lord,
Where is this 10 September 2024 memo?
that is not required because that letter has been reiterated and relied in toto while passing this memo.
How
This
we are
memo, kindly
to-
come to this memo.
That is
Annexure R1.
your contention.
That has to be there. The statement says so. Annexure R1.
So 10th of September 2024, his argument is that you have acted even contrary to that.
No. That is clear from this memo itself. That in terms of 10/9/2024,
So where
we are
is the
grant.
10/9/24?
But that I have to take instruction. But that is not relevant in the instant case. Kindly come to Annexure R1 once. In terms of this Railway Board's letter of 10/9/2024, he has been granted the third MSCP on and from 1st/9/2014. That is clear from this.
No, there is no dispute as regards that you have given from 2014.
As per the Railway Board's recommendation of 10/9/2024.
You must show us now that they, in consonance with that we have done.
That has
10th of September 20.
That has to be, my lord. That has to be. We cannot override the Railway Board. That
So
has to.
when we arrived at a finding that it will be from the initial date of appointment.
Initial date of appointment does not include training period. That I have relied on several
Then,
memos.
your SLP has been dismissed, sir.
Yes.
Our finding was it has to be from the date of joining.
Initial appointment. Now, what is the initial appointment?
That you are not to interpret. Our order is give from initial date.
Initial date does not include training period.
That you argue later when Supreme Court has affirmed why you will not give.
My lord, initial appointment means.
That is an excuse you are making out.
My lord, for the
Come to our finding.
Once, my lord, kindly come to our opposition.
We will come to that. Before that, we want to show it to you. Kindly come to the order which we have passed in contempt. Paragraph 13.
In view of the above procedure adopted by the respondents, the petitioner on being successful in LDC was only promoted and not directly recruited. Hence, petitioner is entitled to the entire service rendered by him from the initial appointment for all the benefits, including MSCP.
So this is the finding. Now you are saying initial appointment means excluding the period of training.
Because that was.
This is your contention.
I have supporting memos also. Kindly come to our opposition.
But you did not agitate that when we filed it. Have you filed any modification application?
Well, this issue was never German in the writ petition.
So we have, whether it was German or not, we don't know. We have made a finding.
Finding initial appointment subject to my lord's approval.
Initial appointment we have made. You are saying we will not give it from initial appointment?
No, initial appointment means 1984. That is what we are saying. We have never said that we will not grant him from initial appointment. We are saying his initial appointment is from 1984.
Show us that.
A memo is there. There are several memos. So kindly come to paragraph 7 of our opposition. May I place it, Madam? I further state that as regards to counting of seniority, it has been dictated by catena of circulars and notifications issued by appropriate authorities that the period spent on training should not be counted towards fixation of seniority. Furthermore, the term regular service for the purpose of MSCP, not for the purpose of pension, for the purpose of MSCP scheme will commence from the date of actual joining of a post in direct entry grade on a regular basis. Now I will kindly come to the several memos that we have relied. What he is trying to say is that
spent on training should not be counted towards fixation of seniority.
What he is trying to say that
the term of regular service for the purpose of MSCP.
Regular service কথা তো হচ্ছে না, initial service এর কথা হচ্ছে. Playing with the words.
From the actual joining of the post for the party for the regular service for the purpose of MSCP, we recommend from the date of actual joining. Actual service should be counted from the strenuous continuation. It is thus evident that first financial will be applicable on compulsory payments of regular service from the date of actual joining. বলতেছে actual joining of post. হ্যাঁ সেটা বলবো।
He doesn't show it, sir. That is service, that is initial account. They will take it. But the
Actual joining of post. Actual joining of post ওরা বলতে চাইছে has to be for that notice. এটার জন্য সার্কুলার, yes, with circular you are relaxed.
Page 11. This is why not similar to the case that for the trainee in our profession
Page
also.
11 circular, my lord, I am disputing. This is original.
Yes,
this
yes,
is a-
circular.
I am
Then
disputing.
he has to file a separate
This
writ
is no
petition.
law sanctity in the eye of law, because my lords know every railway board circular has a article 309. There is a RV number, or neither, my lord, there is a CPO serial number. There is no number in RV number, no CPO serial number. In bottom, my lord, there is a bracket, authority railway board letter number such and such, dated 5/5/2015 and 2/7/2015. I have searched out, my lord, enter 2015 circular in website, my lord. My lord, there is no whisper in this date.
Let him complete what, yes.
Well, this is just like in our profession, if the training, one person joins as trainee and thereafter he or she gets enrolled, then he will be treated to be an advocate from the date of his enrollment, not for the training period.
Let that advocate be satisfied with that.
Now, my lord, may I
Not
satisfy
applicable.
your lordship?
Let the advocate will be satisfied. You cannot be satisfied.
Well, this is similar case. Page 11, my lord.
No, Mr. So please explain to us. We have arrived at a finding that it should be from initial appointment. If you wanted modification of
Sir.
that no, it will not be from initial appointment. It will be because the railway circular say that it will be counted 6 years after the first. 6 months after excluding the portion, after training portion. This stands good, bad, indifferent. This stands. So this order has been affirmed by Supreme Court. So the finding that it should be from initial appointment has attained finality.
We are granting him from initial appointment, but that is in 84 because
You are granting initial appointment, are treating the same, excluding the training period.
yes, because his service book, if I have asked my officer to bring the service book also. In the service book, it will be shown that his first promotion he obtained in 1985. Had he been appointed in 83, in 1 year, in 84, he would have obtained the first promotion.
That
is
does
not
not
the issue here.
satisfy us.
That is the initial appointment training period. My lord, kindly come to page 11.
Yes.
The first paragraph on the question regarding consideration for grant of financial upgradation under MSCP scheme in cases where prescribed training period has been curtailed in the exigencies of service. The matter had been under consideration of this office in consultation with Railway Board for some time. MSCP board now wish to clarify that regular service for the purpose of the MSCP scheme will commence from the date of actual joining of a post in direct entry grade on a regular basis, and grant of financial upgradation under the scheme to an employee is no way related with the respective seniority position of the concerned employee. So MSCP should be granted on the actual joining. That is the 84. Now the next memo at page 12.
Yes. Actual joining. This is your circle. We have said it should be from initial appointment.
Actual joining is the initial date.
No, you are that is why board is clarifying that what will be regular service. Regular service will be from the date of joining on regular basis, and grant of financial upgradation to an is no way related with seniority. It is not seniority.
The MSCP.
Seniority, if you have calculated, then you could have excluded. We are not on seniority. We have made a finding it should be from the date of initial appointment.
Now, for what we are on is that as now the dispute was.
You are arguing that initial appointment means the appointment
Yes.
after completion
Yes.
of training.
Because he was an apprentice.
This you ought to have taken the stand in the writ petition.
Well, that was
already-
never the issue, German. They let him show one paragraph from the writ petition that he raised this point. Well, if everything has to be,
All the juniors have been given. You cannot take
no,
any.
juniors were not
Batchmate,
given. Juniors were appointed through a different channel. That issue was raised at the time of hearing of the writ petition. My lords did not concede to that argument. That was the issue before in the writ petition, hearing of the writ petition. Now again a writ petition hearing is commenced on the basis of the writ petition in a content petition.
Because of this reason that even after affirmation you are not complying.
Well, initial what
It was not even your submission that when you are directing that grant the third MACP, you should clarify that the training period should be excluded.
that was never the issue, German, my lord, at the time of hearing. Let him show one paragraph on the writ petition.
No, issue, Mr. Vasu, you are,
Mr.
Mr. Ghosh, you are taking a point. We are not adding anything to our order. Had it been a case that we are adding any rider to our order or interpreting order as fresh, chapter is closed now. Initial appointment confirmed by Supreme Court.
And what is initial appointment? That is yet to be
That is
decided.
you give it, you agitate.
For that, my lord, what we are saying, that we are giving him.
Who is the
Was the CPO, my lord, principal CPO.
Ask him to be here. Let us hear you have given an opposition. We will consider whether we will send him from here or we will decide. You cannot sit in appeal over our order. That
No, we are.
My lord, you have said it is initial appointment. Now let me give you an example that what is initial appointment. If that had been your eyesore, you should have pointed it out at the time of delivery of the judgment.
Well, that was never raised.
That is not the impugned action.
Ask your
My lord, my lord, may I
My
make one submission, my lord? If my lord directs, we shall grant him from 1983.
Give it.
My lord,
CPO has not to will not appear.
my lord,
We are passing an order of his personal appearance.
no, my lord, kindly do not do that, my lord. We shall grant him MSCB from 83. My lord, we shall do that.
When you will pass the order, tell us.
Kindly give some time.
Kindly give some time. This is not your CPO's order. Huh?
You're asking for a direction.
No, I am asking for a not direction. We are saying, it is our submission that we will grant him MSCB from 1983, treating him to be an initial appointment. That we will do. Kindly do not, my lord, call the officer, my lord. We will do that.
In course of hearing, Mr. Ghosh, learned advocate,
original. আরেকটা দুটো Lordship, I filed the
But I am for the petitioner.
Lordship, I'm filing the affidavit of compliance, Lordship. But
I've received this,
but
but
in the affidavit of compliance, Lordship, I must point out certain aspects to your Lordships. Lordships, the order passed by your Lordships is in the contempt application, page 42. This is the order dated 12th of September 2017.
Yes,
The contempt application, page 42, that is the order, Lordship.
yes.
If your Lordship comes, I'm just
Is
placing.
allowed and the order set aside.
Yes, Lordship accordingly is allowed and the order dated 7 December 2016 passed by the learned tribunal is set aside. Petitioners will be entitled to the grant of third financial upgradation in the grade pay of 4,600. Respondents are also directed to refund the amount as recovered from the petitioner's salary within a period of 4 weeks from date. Lordship, so the order was in two parts. First is grant of MACP and second is refund. Lordship, we had challenged the order before the Honorable Supreme Court, thereafter a review. Therefore, there is this delay. In fact, a period of 4 weeks from date, which was the time limit stipulated. Lordship, we had initially filed an SLP, thereafter a review, then
Review order when it was disposed of.
Lordship in 2024, Lordship.
Then
Thereafter,
what
we
is
have
the problem?
now we have the problem is in respect of 4 petitioners, Lordship. If your Lordships will kindly come to the, we have given the refund to all, but Lordship will kindly see paragraph 13, page 4. There are 2 petitioners, namely Utpal Mullik, petitioner number 33, and Hiranmoy Mujumdar, serial number 21, who have not completed 10 years of regular service from the date of the second promotion, nor completed 30 years regular service, which are mandatory for grant of third MACP, and have already retired from railway service. As such, they could not be considered for the third MACP. Lordship,
So you are not complying with our direction.
Lordship, now this part we could not. Lordship, we have stated before your Lordships why we could not grant that, because they were not eligible and they have superannuated.
But madam, that is for you to decide in review application. You should have said that.
I understand that,
Now the
Lordship.
order
Now,
has been passed.
because Lordship, the order was
Right.
Lordship. Then I think if it would be better if my learned friend could.
Yes.
Lordship, Lordship, the order was passed, Lordship, as we find the order was passed without exchange of affidavits. I mean, for 38 people in general. True. Now, when we come
Now
to
you have given to all others.
all, the second part of the order has been
Recovery amount has been
recovery has been returned to all.
returned to all,
only-
except these 2%.
No, that has also been returned.
Very
It is
good.
only,
In
Lordship,
respect of these 2%,
the MACP, the third MACP,
that cannot be
that
given.
cannot be these 2 persons and Lordship, 2 other petitioners who are not yet eligible. They have not yet completed. So that is still awaiting. Like paragraph 14, Lordship. We have stated everything, Lordship. There are 2 petitioners, namely Shujit Kumar Das, petitioner number 8
Madam, we have said that you grant to all the petitioners the third financial upgradation in the grade of rupees 4,600.
Yes.
Now you are saying that except these 4 petitioners,
We have granted all.
we granted it to all. But these persons have not completed regular service.
2 have superannuated and 2 have not yet reached the third phase.
But
That
still
is
you-
what, that is, I mean,
that
once
issue
they
is
reach.
closed. That issue is closed, Mr. Anand. That issue
No, because
whether you
at
can
that point
agitate
of
that.
time, Lordship, there were 38 petitioners and all the petitioners. I mean, it was not that the fact was that. That is why I'm saying that it's not nothing deliberate. This fact was not before your Lordships either. It was their prayer, and this is, and that is why, Lordship.
You recovered whatever excess is required to be recovered for this compliance, recovered from the officers.
Lordship, this is,
No,
no,
what is your argument to that? We have passed an order, give
Lordship.
to all 4,600
Lordship.
and refund the recovered. Recovery has been
done.
refunded.
Recovery
Because
is
the
done.
first part you have complied in respect of
34.
34. You are saying these four persons are
two-
not eligible.
2 have superannuated
Hmm.
and 2 are not yet eligible.
So that issue you ought to have agitated in SLP.
Lordship,
Either you took it in SLP. Review also, I don't know whether
Lordship,
you
that Lordship,
now, how can we give you this
Lordship,
leverage?
Lordship, this is
It is a question of refixation. They have to have retired. So it will be granted and revised and given the consequences.
so like 2 Lordship, they are to get it at when they are eligible at that point
Where
of
is the
time.
review order show us?
Lordship, I don't have it with me. Then I'll get the orders, Lordship. I'll get the 2 orders.
Yes, what is your
I don't have it. I
But,
don't have it with
that
me here.
exactly was the point before the Honorable Supreme Court in SLP about the non-eligibility of those.
So we were not present there.
Be that as it may, my lord. Be that as it may, my lord. The another part of my lord senior my lord submission about the grant of the MSCP to the other incumbents has been my lord given. The other part of recovery, it is not refunded back. First part is complied, second part could not be complied. So my lord, first part also is not complied. I tell your lordship, I'll be my lord, taking a lordship leave so that I can take an exception to this, because I will be bringing on record itself, because they have my lord, I have got the documents also today.
No,
They-
you are meaning to say that recovery has not been repaid.
My lord, the recovery is not repaid to some of the individuals, that is true, which they are right now admitting.
That is for part. No, they are saying recovery amount has been given to all.
In that event, my lord, the first part, I'm sorry, it's my wrong
First part
understanding.
has been complied in
sorry,
respect
sorry.
of all except 4 persons.
Yes.
On X and Y grounds.
My lord, yes, follow, my lord, it's my wrong understanding. So, my lord, that part, my lord, that my learned senior is talking about, that 4,600 benefit has been given apart from only these individuals, my lord, that is also not right. I tell you, lordship,
Let
I
him
have.
file an exception.
I'll do that.
Because
My lord,
that,
I tell you, lordship,
Then
why?
let-
Because they have granted it from the year 2020 when the specific
But
order
Mr. Rai,
was of 2010.
if the eligibility is not there,
My lord, that point is already turned down by the Honorable Supreme Court.
you
Though,
bring
that
the
has to be.
SLP, this was argued before the
my
Supreme
lord, this
Court.
was pleaded in the special petition.
Acha, bring it to us.
And also, my lord, they have been given with the MSCP from 2020, when, my lord, the specific circular and the order was from 2010 itself. So that is an admitted position right now, today. Because I have got the
they have given the MSCP.
from 2020, with effect from 2020.
We did not say from which date you have to
Because, my lord, the Honorable Court's direction was, my lord,
hard financial merit for in
Within
the
a
scale of such and such.
my lord, it was, the writ petition was initially preferred, my lord, so that the benefit would be granted from 2010, because I have in the contempt application annexed the prayers also.
That order is
Now,
not here.
now I tell you, lordship, even if I just assume that I am living from 2010 to 2017, from 2017 lordship has directed. Now they have, my lord,
They have
given
given you from when?
2020, with effect from 2020.
That is their eligibility.
I will be, my lord, taking this, your lordship, my lord, by way of an exception. I
Let
do that.
him take an
Kindly, my
exception.
lord,
and
grant
that
me
will-
liberty to do this. And after the dismissal of the review also, my lord, I have got the letter, my lord, to produce to your lordships, that they have
Bring those
sought for, my lord, permission from the general manager to comply with the Honorable Court's order. In my respectful submission, that is itself is a country. After the dismissal of all the matters, I'll be placing your lordship by way of an exception to this as well.
Let him do that.
Salam, your conduct is not proper. You appeared before us on 21st March and said, don't take any steps, we are complying, we file the.
No, that we have, because it was after
But
the
you also
rejection.
know that this is not compliance.
Lordship,
If your
I have
officers
very,
have the
Lordship,
audacity to take
Lordship,
fresh
no,
grounds which have
Lordship,
attained final,
Lordship, I mean, where Lordship, this is not,
will be facing problems. If you
Lordship,
hold
let my
against
learned friend file a exception, let us, let, let,
affidavit of compliance means order has
have
been
been complied,
complied
but
with.
these two are the, that is why at the
We have
very
said
outside.
you have prayed for an accommodation. Then
Yes,
your
I have,
officers
yes,
have told
Lordship,
you on that date
yes,
that
because,
madam, we have not complied in respect of these 4 persons. That was not the picture given to us. Neither it was given to you. Otherwise, you would
Lordship,
have certainly told us. You were
Lordship,
appearing online on that.
on that day I was appearing,
So
on
your
time.
officer is not acting properly. He should not mislead his own counsel, because on his submission you have, on his instruction you have said that stay your hands, we are filing a
A
compliance report.
compliance report.
Then why this audacity? Who is your officer?
Lordship, Lordship, he's the general manager.
He cannot play with court's order.
Lordship, in my humble submission, Lordship, this was
No,
the
they have
constraint.
neither they have misled us, they have misled their own counsel. This is not proper.
Lordship,
Otherwise, you would not have prayed for affidavit of compliance. Now, exception, you will give a reply. We don't know whether the person will be alive to get the benefit or not. Who will be responsible? Your CPO will be still there. This is not fair.
Lordship will kindly, Lordship will Lordship, let him, because
Madam, please, Miss Alam,
let
you are
him
our
file.
officer. We
No,
believe.
Lordship, that is why let him file. Let me also understand what the
Now, please
situation, Lordship.
intimate to him that why did you tell me that I
I'll
will
tell
file
him that,
affidavit
definitely.
of compliance?
I will.
We can
I will.
promote draw up contempt for this reason.
I will, Lordship.
Who is this person?
Milind K. He's the office. He's a general manager, Lordship. But this is
These persons are very reluctant. They think they are central government employees. High Court cannot do anything against them.
no, Lordship. I don't, Lordship. That
So
is not. But this
they
is.
should not have given this instruction to you.
This was the constraint. As I in.
Please convey our dissatisfaction to the concerned
definitely.
officer.
Lordship,
And
I
if
shall.
he find, he will be in problem. I am telling
Lordship, I shall definitely.
you. He has
do
not
that.
only misled their own counsel, they have misled this court
Lordship,
also.
I shall tell them. I shall inform them.
Pursuant to the earlier order of this court, Miss Alam learned advocate.
Leave.
Let's have the copy upon the respondent. Short duration was passed to file supplementary affidavit annexing the relevant documents and records of this case, because when I filed the.
Have you given copy to?
Yes, my lord.
So, my lord, and another is.
Where is
director of
your
class.
supplementary?
Supplementary today I have.
Supplementary affidavit is more than your petition.
Because, my lord,
Nothing annexed to the petition. That
is why the initially we just referred the
Mr. Das, you want to
Documents which are very much
you want to use any opposition or
No,
we
my lord,
should
no
proceed?
opposition, my lord. It can be done without opposition, my lord.
All right.
the point involved in short, is some amount of the retirement dues of one deceased employee who happens to be my mother-in-law, deceased mother-in-law.
Please put on the mic.
Yes. Yes, my lord. My lord, who?
চলছে না নাকি? বাতি জ্বলছে?
My lord, my lord, these appellants demands the retirement benefit. শোনা যাচ্ছে?
তো ডঙ্গি শট।
Demand the retirement benefit of the deceased mother-in-law. Now, the previous in
So
previous
there is no scope for any interim order.
no, I am not seeking interim order. What my last day decision was passed upon my learned friend that
Acha, let us go through the order, then you will have.
only one thing, my lord, for the benefit of the
15th of July is the order impugned. 15 July 2024.
my lord. My lord.
একটু পড়ে নি। Yes, what compassionate appointment you will give?
Nothing, my lord. That is the whole thing. We are not
What
at
is
all
your-
read for in the petition, in which the impugned order was passed. We have not pressed for any compassionate appointment because I am 74 years old. The earlier occasion, it was when directed by the Honorable Justice Sambhuda Chakraborty, Leading Justice. But thereafter, the fact-finding authority, they have taken a decision that I am not eligible. Since I have not been able to produce the copy of the death certificate of my wife and the Aadhaar card or Epic card, etc., I cannot establish my relationship. That was the first round of litigation. Thereafter, my lord, thereafter, ultimately, there are three litigations.
So you are not claiming compassionate appointment.
No.
So in, which order did you challenge in the writ petition 1484?
My lord.
What was the subject matter of
Subject
challenge?
matter of challenge is that when I got the
No,
document.
Mr. Banerjee, you will argue. Please answer our queries.
Yes, I am
first.
directly answering. Kindly come to the page number 69 of the supplementary.
69
of the supplementary. When I obtained those documents, public documents.
Now, first come to page 31. You
Fine.
have challenged the order of 28 August 2023,
Yes.
annexed at P10.
Consider the representation dated 28 of
No, no.
July.
31, your prayer in the writ petition.
Yes, yes. Yes, my lord. That is, my lord, will be available in the annexure P10, that is in page number 76. I am agreed by this triptych order. I filed a writ petition. 76.
76.
This finding made me a little bit unhappy because these findings in a very short manner, because I produced all documents regarding the death certificate of my wife, where it is clearly apparent that I am his husband and even my mother-in-law.
They are in this letter, they are saying you have been communicated about the recent order on 4th December 2020.
That
Where is that order?
That is my page number 62. The operating portion. 62 and 63. A submission is made from this side that when this order was passed, admittedly I could not produce the relevant documents to establish my relationship with my wife. Her name is Bijuli Mijian and my mother-in-law's name is Mukhoti Mijian. And the case is that Mukhoti Mijian was working as the worker of the ECL, mining worker. Now they are very much illiterate. I have taken this out. They could not read the order properly. Neither they can come to Calcutta High Court, but somehow there is a accrued property need. Money is there accrued in favor of the name of the Mukhoti Mijian lying with the ECL authority towards the retirement benefit. Some amount is there. Now question comes that whether can I claim as a son-in-law of Mukhoti Mijian or not.
That was rejected by an order.
Thereafter, writ petition filed, writ petition was rejected that for some reason, ultimately culminated up to this previous writ petition. When in the input order was passed, I filed before the writ court that I made a representation with all required documents because nothing can stop me from an amount which may be lawfully entitled to me. Because the coal wage agreement, national coal wage agreement is there, that the definition of the dependent is stating that also.
Are first establish that you are the husband of the
Yes,
deceased
that
daughter.
is why I filed all documents.
That you failed to establish.
I have filed, my lord, before while impugned
Did
order
you
was
challenge the order of 4th December?
my lord, kindly, my lord, for
4th December 2020 order you have not challenged.
yes, yes.
What
yes, that is why the first petition was filed, challenging that order.
No, my lord.
No, my lord.
No.
No, my lord. This was challenged all along.
I think so.
This was not challenged. You made a further representation. That was communicated to you by page 76.
I'm coming to that. There was a little mistake by this appellant when he has filed the first petition. He was under wrong impression that because everything was going on in the COVID-19 period.
Mr. Banerjee,
I'm
don't
coming to
make
you.
the submission. Only answer to the point. Court has given a detailed judgment saying that you have failed to establish that you are the son-in-law of the deceased and you have not been able to establish the dependency. Moreover, the fact that you are the husband of the deceased daughter.
There is a wrong finding, my lord.
So if it is a wrong finding, go to civil court.
No, my lord. Only
If that is a wrong finding, go to civil.
I will just think one thing. The court must take it note that I have filed the documents. Court has said in the impugned order, I have not filed any documents regarding to establish my relationship with said Mukhudi Vijayan, who can be my mother-in-law or not. Court said that no document has been filed. I placed those documents before the writ court. Interim impugned order was passed without considering those documents. Impugned order was passed. My lord, firstly, of my
each document.
This document, my lord, will reflect from the my representation is, my lord, page number 69. Kindly come to page number 69 for once. My lord, along with my representation, page number 69 is my representation. Kindly come. Page number 69 is my representation. I have only 2 points to submit, 2 or 3. I made a representation before filing the petition where the input order was passed.
Yes.
Then this representation was dated 28th of July 2023. I annexed the document
17th of August
2023. 28th of July 2023, page number 69.
Come to page 76. They have said that in reference to your letter of 17th August 2023.
Well, there was another representation. Last one I am referring.
Page 69.
I am last one I am. This representation when made, I categorically filed one very important document that could be considered because this document is cannot be prepared by me. It is an epic card. It is a death certificate. Death certificate of the deceased wife of the appellant. Good name.
So this representation was made 3 years after dismissal of the writ petition.
There was a court proceeding was going on.
Your writ petition was disposed of in the month of in 2017.
First one.
That it. Now, in terms of that,
order was passed in 2020.
4th December 2020.
Thereafter, I filed a writ petition.
After 3 years.
No, there was other writ petition also. That is why I am trying to put your losses consideration that there are other writ petition.
To forget about that. Ultimately, you filed it 28 July. Yes, what you want to show?
Now, my lord, kindly come to page number 74. I placed the document. My wife's name is Bijuli Mijian. Name of the deceased. And the relationship is that my name is appearing as a spouse in the third line, third row.
All right. So this was one document.
Thereafter, my name of the mother of the deceased, Mukhudi Mijian, is there. Who happens to be the ECL employee, deceased employee, who wants some retail benefit, that is accumulated in the ECL's account. Your lordship, in the last day, last occasion, when your lordship was observing our small submission, asked my learned friend to disclose to the court that what is about that amount which is kept pending, whether it is kept pending or it is already released. I do not know, my learned friend. If it is already not released, my lord, I have somehow arranged some documents. I have got those documents.
What those show us?
So that is why this document has been placed.
Okay, one document is this.
74.
Huh.
74
When was it issued? When was it
establishes
issued?
my relationship.
This was issued on 16 September 2017.
17. I could not obtain. I could not obtain. It is not so easy, my lord, you will also appreciate. It is not so easy to obtain a copy of the death certificate where I reside, but the status of the litigant, we cannot appreciate.
Mr. Banerjee,
I
you
could
are our officer. Don't say something which is not accepted.
This is really, sometimes it is hard.
Just because the person has come to you.
Our country is now going into a total hodgepodge. I am also.
Don't link other issues with this.
Yes,
You
consider my practical difficulty. Right?
Yes, but what more document?
This document has not been considered by the single bench.
All right.
It would have considered. Second is, I placed my Aadhaar card. Aadhaar card also proving my identity. These two documents, if considered, the ECL authority would have said something in my favor. They say that I am not his husband. They say they have to go through the court. They have to approach the civil court for getting my legal status, marital status. They are not doing so. Keeping the amount, these documents was admittedly placed subsequently. Now this four
we ordered a BCCI to consider the কোন ডকুমেন্টে এটা কোন রিট পিটিশন? এটা তো 4438 মানে এই রিট পিটিশন না,
এটা আগেরটা
4438 টাই কি অরিন্দম আলটিমেটলি ডিসমিস করলো অরিন্দম
না, এটা ছিল 148
না 1360 অরিন্দমের অর্ডারটা
148
পেজ 30
না, এটা
কেন
ক্যানভারা 30 স্যার না স্যার স্যার ক্যান টু
থার্টি ফাইভ এটা হচ্ছে 148 একটু বুঝে নি 1484 এর ডিরেকশনটাতেই না, এটা তো আবার 13604 তার 2017 তার 2017 অর্ডারটা দিতে এটা হয়েছে অন দি বেসিস অফ 8/2017 এই যে 8/2017 পেজ 24 এবার লতিকা কোনটাতে পাস করবে? অরিন্দমের অর্ডারটা হচ্ছে 14 এবার লতিকার অর্ডার কোনটা হচ্ছে? এটা তো
ডিসেম্বরটা চ্যালেঞ্জ করলো রবিদা।
সেখানে ডেথ সার্টিফিকেট infirmity failed to produce general identity proof himself and death certificate produce করেন Joseph ID under your suppression his wife after audit has happened now by 6 to 11 September 2007 সেটা হচ্ছে পেজ এই যেটা দেখাচ্ছে না এটা তো 16 সেপ্টেম্বর এখানে বলছে 4 সেপ্টেম্বর পাস্ট হবে অন 16 সেপ্টেম্বর ডেট অফ ডেট হচ্ছে 4 সেপ্টেম্বর 2007 They are good show. They are such one. They are pastering but not being seen to notice. Yes.
Well, first argument is that a affidavit is required from the ECL. Affidavit is very much required according to my humble
So that is the document.
Why, my lord?
Page 74.
This is the document where I can establish my relationship. Apparently, a public document.
Yes, what you are saying?
That is my stand that my wife's name is Vijuri, my mother-in-law's name is Mukhuri, my name is
Yes.
Sriram, and date of death of my wife, from which date I am legally entitled. I am coming under the shoes of the.
What is your next argument?
Next argument is that what is the amount ECL has not yet.
How you are bothered about that?
Because, my lord, I am claiming
You are not entitled.
Even if I am not
If
entitled.
we find you entitled, we will bring that.
If
show us what more document you want to show.
Another document regarding my identity, they have doubted that who am I? Actually, I am a wrong person or a fictitious person or not. Page now 75 is the answer to that. Here I stated that this is my epic card. You can verify this epic card with your portal. You can check my identity. You can also take note of the other documents. Those are public documents. And now, first limb of argument I made against at the cost of repetition, that the amount which is like wrongly, badly, may not be entitled. ECL authority has not taken a clear stand whether any amount is there. Secondly, that can only be asserted by an affidavit. Second thing, if they want to deny my relationship, that I am not the wife, I am not the husband of the Dijoli, they have to say it in a clear terms that why I am not being held as a husband. They are not saying. They have fact-finding authority stated I am not legally entitled. Why I am not entitled? That point of time, I could not produce those documents. Now I can produce those documents. I stated that I am a poor litigant. I have stated I am a very poor litigant.
His wife after what did petitioner submit?
Now,
by way of an exception, document. This document was produced by you earlier. Page 79. Now by second line, now by way of an exception filed before this court,
Yes.
petitioner seeks
I-
to rely on a
I
document.
produced, and what was the observation of the court? That court clearly stated, I am not going into the deep of the disputed question of fact.
Yes.
And they have not decided. That is my first submission. First day I was making submission. I am not submitting that this point was ever adjudicated by
So
any
you
court of law.
produce the certificate before.
Certificate I produced, court could not consider, court did not want to go deep into that. Then I made a
Then-
representation.
No, then did you challenge the order of the writ court?
No,
So-
because my lord, that portion, my lord, clearly stated that only on the point of misrepresentation of the fact, suppression of the fact, I was little bit punished. I was punished by the court. I do not mind because my failure to give the documents, court did not go.
No, you brought the document, but the court
Court did
said.
not ignore. Court ignored.
No, court did not ignore. Court said that he has produced the document,
But
genuinity is in dispute.
I
As
do not-
such, these facts cannot be decided.
So that point has not been adjudicated at all. That is why
So not adjudicated, you should have preferred appeal against that order.
one thing is that I could have prepared a bit.
Yes, what is
Second
your
thing is
next
that-
point? Mr. Banerjee, don't argue a thing which is a closed chapter.
My lord, not a close, my lord. These points,
If we ultimately
I have-
find, we will,
I have lost
will
this.
appropriately deal with your.
My lord, I have lost this case because of.
Yes, anything else you have to say?
Yes, my,
Yes.
another thing is that, the main point, the coal was.
Limit আছে. Yes, Mr.
I am coming, my lord, very shortly. My lord, kindly come to page 108.
We have put a question to you
Yes, my lord.
that Mr. Banerjee, you have produced that certificate in the earlier round of litigation. Court said that genuinity is doubted. So it is a disputed question. I cannot decide.
Doubted not by the court,
Let
not
us-
by the authority. Doubted not by.
Kindly come to page 80, 60, 79.
Yes, my lord. My lord, court.
Now, by filing an exception, petitioner seeks to rely on a document to show wife passed away on 4/7. Genuinity is dispute, assuming that petitioner substance that was not brought to the notice of the authority at the time of hearing. This raises a doubt as to the genuinity of the petitioner. The conduct is not well appreciated, not willing to go into disputed question as to whether petitioner is the
That is the
subject of.
argument.
Furthermore, have conducted proceeding with fairness and it was disposed of. After this detailed order rejecting your case, you did not prefer an appeal.
No,
You filed a further representation annexing the same document.
because why I have done so, that I am explaining, my lord.
Anything else, Mr. Banerjee?
Yes, my lord. The court, I am challenging this improved order. First
Oh,
point,
you will challenge that order before us now.
improved order.
Justice Banerjee's order you will challenge.
Mukherjee.
Justice.
Not, I am not.
Yes.
Justice Mukherjee, the first point where I am raising this. is
Yes.
on of the mind. Why I am saying. My lord, kindly come to the internal page 4 of the improved order.
Internal page 4.
The petitioner on the middle paragraph, the petitioner therefore.
Where you are reading?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. After 10 lines from
The
the top.
petitioner therefore, right?
Petitioner therefore one could not have claimed even the service benefit as the dependent son-in-law on that date. Moreover, the petitioner has not produced any document either before this court. This is very, my lord, hurting me. I have produced this document before this court, before the earlier court. Even after that, the court cannot, my lord, without, my lord, having a reason, my lord, proper reason. The court has stated that I have not filed any document. I filed the document.
Please read the whole sentence.
Then I'll either before this court in the previous 2 rounds of litigation or before this or before the ECL authority to demonstrate his dependency on his mother-in-law.
Yes.
That is why the court observed that I even did not approach the ECL authority to produce my dependency. I am dependent. I unfortunately could not produce. Practically speaking.
So where you have produced before us dependency? You are trying to establish
That-
dependency on the basis of
that-
the death
yes.
certificate.
Then, my lord,
You are trying to dependency. You are trying to prove on the basis of page
24.
Page 60, the dates, page 74.
My lord,
This is the only document of any other document of dependency you are showing.
not now.
Acha, very good.
Not now.
Not now means you have don't have.
Not available on the record.
Very good.
I cannot make any comment. My lord, kindly come to the last paragraph. Thus, how the court came to a conclusion that I am challenging. Thus, on both counts, that is in terms of the National Coal Wage Agreement, in short NCWA, also under the general law, that is Hindu Succession Act 1956, the petitioner did not qualify for maintaining a claim when the daughter of the deceased employee was alive. That is not the case. Case was that after the death of my wife, I came under the shoes of the wife. When my wife came under the shoes of my mother-in-law, this was the succession.
Till he was alive, you
I could not. Thereafter, my lord, this point, my lord, ultimately, my lord, reached to a conclusion that I am not legally entitled. Now, my lord, I have annexed the coal wage agreement.
wait, coal wage agreement you will go later. Page 40, kindly come.
40 of the supplementary.
Not page 40, internal page 6 of the order. The petitioner also could not produce any document as recorded in the order of 4th December.
Petitioner also could not produce any document as recorded in the order dated so and so, passed by the competent authority of ECL, such a plan, EPIC, again the same thing. I produced. Somehow I have been pestered into the situation. I failed. I
All
really
right.
sorry for that.
Anything else, Mr. Banerjee?
I really sorry for that. I could not
Anything
fail.
else, Mr. Jan?
Another thing is that whether coal wage agreement has defined the definition of the dependent, the son-in-law is well covered. Son-in-law is well covered. I have
first prove that you are son-in-law.
That is, if I
So you are trying to prove on the basis of two documents, your Aadhaar card and the death
that
certificate.
should be considered.
So those have been considered already. Matter has attained finality.
Or the language.
Sorry,
is
Mr. Banerjee.
Our language is otherwise. If you kindly go through the my lord without my lord coming to a
This is
conclusion.
nothing but a vexatious litigation.
My lord, the amount.
For which, see, you are saying na he's a poor man, so we are not imposing cost upon him. You are repeatedly destroying court's hour to establish a false claim.
Then, my lord, one thing, my lord, may I just, whether I am false or wrong, my lord, another chapter. I am a lawyer. I am acting on the instruction of the.
No. We are not telling it to you. We are
Look, my
telling
lord,
it to your
if
client.
the litigant is otherwise, my lord, getting some bad remark, it comes upon us also. The lawyer representing him could not check the document. That is why, my lord, it is not permissible to me also, because I could have left the brief. Why I am appearing in the third round of the litigation? I thought that a poor litigation is trying to establish a relationship. ECL authority has not indicated the amount, quantum of the money. Second thing is that if I am not entitled, at least one more chance to be given to me, I will produce the document. ECL, if not satisfied with the document or is otherwise find that this document is fraudulent document, suppose ECL authority will not act. But they are not saying it is manufactured. They have not said it is manufactured document. That is the gross of the entire carriage of the proceedings. If they can say that this is a manufactured document.
What is the NCWA, coal wage, what you are showing to us?
That is only, my lord, there is a definition of the dependent.
Show us.
The definition of the dependent is.
Show us.
Yes, page 108. If that thing is considered, my lord, my grievance is over. I may not be entitled, but this. No, done. 108. Kindly come to my lord, the 108 9.4.0, page number 108. My lord, the other portion have a similar reflection. The dependent for this purpose means that the wife or husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for the employment to other, the widowed, the daughter of the widowed daughter-in-law or son-in-law. Well, both my daughter-in-law, son-in-law, they can claim the retirement benefit. The ECL cannot, my lord, cannot. my lord, take away the determined benefit of a deceased employee. They have to find out who is the legal heirs of the disease. If they are not happy with me, they at least can consider this document. If they are not at all happy with me, if I am so bad person, do not release upon me. But my lord, give me a small chance, 7 days representation to be considered to these two documents, then you still can.
Yes.
Nothing else, my lord.
Yes, Mr. Das.
My lord, basically, my lord, I have 3 points here, my lord, to say. First of all, my lord, the facts are need to be stated, my lord, chronologically. Probably Mr. Bhattacharya, he has not said it. 3 round of litigations, my lord, first in 2017, thereafter 2023, thereafter 2024. And, 2023 and 2024. In the first writ application 2017, my lord, at that time he declared his age to be of 74 years. All those orders are annexed here, my lord. I can show, my lord. 74 years, and at that point of time, it was.
No, he is not claiming compassion.
At that point of time, he claimed compassionate employment. Now, court said it's not possible, and court said you can make a representation. It's here to consider within a stipulated time, my lord.
Where is that?
Now, my lord, that order is, my lord. And
That
first
is
of all,
quoted
before
in the
page 24, my lord.
page 62. That order.
Page 24 is the first order, my lord. 2017's order, 8th of August 2017. Why Justice Mukherjee, my lord, with the order under challenge, has observed that he is not entitled to, is the answer lies here, my lord, in this order of 8th August 2017, my lord.
Page 20.
Page 24 of the writ petition, my lord, of the application, my lord. Page 24.
Supplementary.
Not supplementary, the stay application.
Can 1.
Can 1.
Can
2, my lord.
Page 24.
24, can 2.
One thing, my lord.
No, please allow me to submit. No, please allow me to submit.
My lord,
Mislead করছো।
That is why I asked for the short affidavit from the CL. Why?
Not required.
Just stated that I have not.
You have finished your arguments, Mr. Bhatt.
Only thing, my lord, what came to their mind, I apprehend that I am claiming the benefit of my mother-in-law, not my mother. Here,
Mr. Banerjee, you have concluded your arguments. Please take your seat. Yes.
Now, my lord, at page 24, my lord, if your lordship kindly takes up page 24, my lord. This is the first order. This is the first order, page 24. My lord, it starts, my lord, second paragraph. This must be reckoned to be a very unusual case where the petitioner aged about 75 years. In 2017 itself, he was 75 years. Claims for appointment on compassionate ground on the death of his mother-in-law, which had taken place about 35 years ago. This because that Mukherjee Mejan, whom he is claiming to be his mother-in-law, died in 1982, my lord.
Yes, very
died
good.
in
Then what
1982.
happened?
Now, thereafter, by this order, my lord, ECL was
Directed to consider
a
what?
representation, next page, my lord.
So after this observation, also court directed consideration.
Consideration
of
for
compassionate
no,
appointment.
not compassionate appointment.
In view of
my
the
lord.
pictures, entire.
My lord, kindly see the last paragraph of the next page, my lord, internal page 2. I dispose of the writ petition by giving liberty to the petitioner to make a representation to the General Manager, Eastern Coalfields Limited, that is the respondent number 6 herein, ventilating his grievances and providing sufficient proof of the status of the son-in-law of the deceased employee, namely Mukherjee Mejan, within a period of 4 weeks. If any such, my lord, this was me. Now he didn't prefer any, didn't make any representation, so we told him to make a representation because there is a court's order. Thereafter, he made a representation. We considered it. We considered it, and we also passed a reasoned order. That my lord, we considered it
after 8th August 2017, he did not make representation.
Did not make representation. Then we had to write letters to him, make a representation. Then he made a representation, and thereafter, what happened, my lord? Then he made a representation. We gave him personal hearing on several dates, my lord. And on those hearings, my lord, we asked him to produce the documents. There is a meeting of the minutes also. I will show my lord.
Order? Representation consideration order.
Representation consideration 2017 order. I have just shown, my lord. 8th August 2017, page 24.
That we have shown. Now, where is the order passed on the representation?
Yes, that I'm showing.
62.
Please. Now, my lord, he is not allowing me to
62, my lord. I'm assisting the court.
No,
Yes.
don't assist me right now. Okay, I do not require your assistance right now. Please allow me. Thereafter, my lord. No, my lord.
Yes.
Yes, my lord. Now, my lord, if your lordship takes up page 62, my lord, now what happened, my lord, in between? Page 62, my lord, kindly takes up page 62. But before that, my lord, before 62, my lord, kindly take up the minutes which starts at page 58. Starts at page 58. And it is signed by the petitioner, my lord. Bottom left. It is signed by the petitioner. He signed it. Now, my lord, kindly come to down to the next page, page 59. Last paragraph. Accordingly, Sriram Maji, the petitioner, was called for hearing on 13/5/2019 to appear before the General Manager, Kunusturi area, since the petitioner did not communicate the order of the Honorable Court within 4 weeks of passing the order. Accordingly, he was not called for present hearing. Now, my lord, thereafter, it starts from the next paragraph. Next paragraph, my lord, the petitioner could not produce any document.
Page
60, my lord. Page 60.
So he was hard on that date?
Yes.
Page
There were
60.
several other days when he was hard.
Page 60.
Page 60, my lord. It's continuing. The minutes is continuing, my lord.
Yes.
The petitioner could not produce any documents either of PAN card, EPIC card, Aadhaar driving license or passport which can establish his identity as Sriram Maji. First is identification, whether he is Sriram Maji. Then his relation with that Mukhoti Mejan. Son-in-law of late Mukhoti Mejan, the deceased ex-employee father, he stated that he applied for Aadhaar card. Now he stated that he applied for Aadhaar card. The petitioner was asked to produce the acknowledgement receipt of Aadhaar or ration card. He stated that he was not having any document or evidence at present and will produce next date of hearing. Further, it is also necessary to hear Srimati Bijoli Mejan, daughter of late Mukhoti Mejan, the deceased ex-employee. Hence, the proceedings of today is adjourned to 8/6/2019.
Yes.
Hence, the proceedings of today is adjourned to 8/6/2019 on the request of the petitioner. And the petitioner is directed to appear on 8/6/2019 along with Srimati Bijoli Mejan, daughter of the deceased ex-employee, late Mukhoti Mejan, and to produce all documents to establish the relationship of the petitioner and Srimati Bijoli Mejan with late Mukhoti Mejan. Ma'am, here I pause for a moment. Even on that day, he didn't say that no, Bijoli Mejan is already dead. Because as per the death certificate, she died in 2017. He didn't say anything. Thereafter, we passed the necessary orders, which is at page 62 of the supplementary affidavit. Here, my lord, if your lordship says, page 62, my lord, it's paragraph 1.2.
Yes.
The petitioner did not submit the representation within the time as asked by the Honorable Court. However, on receipt of the representation, the date of personal hearing to the petitioner was fixed on 13/5/2019, 8/6/2019, 15/1/2020, and 19/11/2020.
Page
62, my lord.
Yes.
Paragraph 1.2. He was again asked to attend the hearing on 15/1/2020, but the petitioner failed to attend the hearing this time also. Further, on repeated request of the petitioner, next date for personal hearing was fixed on 19/11/2020, wherein he attended the hearing. The petitioner, my lord, skipping paragraph 2, my lord.
Very good. Then what happened?
So, my lord, so we passed a reasoned order.
Yes.
We said that you are not you could not establish that you are
Answer to his argument. He has said that my 2 documents were not considered.
No documents, my lord. This is required to show, my lord, why at that time no documents. He could not. Now, what happened? He filed a second writ petition. In the second writ petition, that order, Honorable Justice Banerjee passed that order, my lord. What was the second writ petition for? Basically, that saying that pass a direction on the ECL that they have not passed any order. So we produced this order. Now that order was passed. Now that order, what says, my lord? Now, in view of that particular order passed by Justice Banerjee, my lord, this case is presently barred by res judicata, because that order has attained finality.
Very good.
This is one, my lord, and obviously there is a disputed question of fact, and he has now come up with two documents. One is the death certificate, my lord, which we doubt the authenticity of the same.
And the Aadhaar card?
My lord, I'm coming, my lord. And secondly, my lord, even this death certificate, if it is taken to be true, correct, it also does not say that this petitioner is that Sirammaji who was the husband of Visual Imagine. Visual Imagine once told us, once made a complaint, saying that this particular person is not my husband.
Very good. Anything else you want to?
And one Aadhaar card, because well, from Aadhaar card, Aadhaar card does not establish the relationship, and it's a self-declared document. Aadhaar card is a self-declared document, my lord. It does not establish the relationship. And so far the NCW is concerned, my lord. NCW here, why Mr. Banerjee has shown it, I do not know, my lord. It's not applicable here in this case because he's claiming for the terminal benefits, my lord. And the provision shows at page 108. First of all, my lord, it is not applicable, my lord. Kindly see 108. He has shown 9.4.03. The definition of this daughter, son-in-law, my lord. It's the definition of not son-in-law, the dependents. It's not the question of dependency, my lord. Why, my lord? My lord, can you see the head note 9.4.0? Employment to one dependent of a worker who is permanently disabled in his place. It's not the case here. It was the case when compassion. Page 108. NCW.
Permanently disabled.
Permanent. It was, my lord, this chapter 9, my lord, deals with compassionate employment.
The present writ petition has been, the present appeal has been preferred.
Here is a dispute.
On the earlier occasion, hearing was completed.
With my lord.
Hearing was concluded in item number 10. Only my learned friend's prayer was to submit before your lordship the filled in form, application form. For that, my lord, today it was fixed by your lordship consideration.
When was it last heard?
Last heard on 28th of March.
Thank you. এতে যাওয়ার আগে।
Yes, Lordship. In this matter, Lordship, the candidature of the petitioners was cancelled on the ground that petitioners does not belong to the OBC from central list. That is the main crux of this matter, that the point the employment authority rejected my candidature after the completion of the probation period on the ground that they verified from the state authority that I belongs to a state listed OBC category. And on the last occasions, but in the notification, there is no such specific mentioning that OBC should be from the central list. That is my main submission, Lordship. And on the last occasion, my lords asked me to take instruction whether in the form to get a specific certificate. If your lordship kindly consider page 48 of the paper bill.
Serial number 8.
Lordship.
This was the form annexed with the advertisement.
Lordship.
Yes, what
And,
do you have?
by this form, the petitioner is supposed to get a certificate to
Central list.
No, Lordship, from a competent authority to get the employment as in civil post, Lordship. If your lordship kindly consider page 48, there is a specific mentioning that I request that a certificate in respect of reservation for other backward classes in civil post and services under Government of India be granted to me. And on the basis of this application, before the.
So what did you mention in serial 8?
There, as per my instruction, lordship, the petitioner remains blank. Remain blank. But lordship, my submission in further submission is that if your lordship kindly consider page 51, that is the show cause notice. If your lordship kindly consider the paragraph number 2, there is a mentioning, specific mentioning that you have also produced certificate from the middle point of the para 2, lordship. Page 51.
Paragraph 3.
2. After the Muslim Mandal in capital, there's a sentence started. You have also produced certificate to be produced by individuals of other backward classes applying for appointment to the post under the Government of India in prescribed format, which was issued by Deputy Magistrate and Deputy Collector Behrampur, Murshidabad, vide such and such, wherein it is mentioned that you reside in village Batuknathpur in the district of Murshidabad in the state of West Bengal and belong to OBC A community. After that, the Employment Authority also mentioned that accordingly, you were appointed under OBC category to the post of constable in Shastra Shima Bal on 25th June 2014, video order dated such as such. So after perusing that certificate,
paragraph 3.
Whereas the matter regarding authenticity and veracity of the OBC certificate submitted by you and inclusion of Muslim Mandal caste in the central list category was taken up with the concerned district authority, which had issued the above mentioned OBC certificates, backward classes welfare, tribal welfare, Murshidabad, with a memo such and such. has intimated that no subcaste Muslim mandal has yet been enlisted in the central list of OBC for the state of West Bengal. Lordship, that is admitted that I am not belong to the central list, but the certificate which was issued by the deputy magistrate and deputy collector, that certificate was produced at the initial point of time to provide me the appointment, Lordship. That it is not that they, without verifying that certificate issued by that
So
competent
a
authority.
wrong committed by them, can it cast any favor upon you?
Lordship, that is not
Admittedly, you are not a central listed.
Lordship, admitted.
So we have found, now we have found that you have fairly submitted, you kept that blank portion. So the requirement was that OBC central list, not of OBC of state.
But that is not specifically, Lordship, mentioned in the notification.
What more it will be mentioned, the
Lordship,
form which was annexed.
then a ordinary prudent person, how can it know by the by that
As
individual
like
that-
other prudent persons who have appeared.
And he was aware of the situation.
Yes, you will get your chance. Yes.
Lordship, that is my submission that
So your first argument is that even I have left it blank, you have found that I am admittedly a state registered OBC.
on the basis of a certificate issued by the competent.
The genuinity of which is not disputed.
Lordship.
And you have
Subsequently, they collect information from the other backward class welfare tribunal, welfare.
So this show cause notice was issued on
8th March 2018, Lordship.
18. When did you join?
Lordship, in the year 2014, Lordship.
Where is your appointment letter? Page 39.
Page 39, Lordship.
So you were appointed as a constable on 27 May 2014. Thereafter, when you are undergoing the training period, they issued the show cause.
No, after completion.
After completion of training.
Years of probation, Lordship.
No.
After completion, you joined. And you were under probation. At that juncture, they issued the show cause. Now, ultimately, you replied, this was the show cause notice.
Lordship. And my reply started from page 53.
Page 53, yes.
53 onwards, Lordship.
Now, what is the final order? Page 56. Yes. Now you preferred appeal. Appeal was also dismissed. Against that, you came up to the writ. Now, so come to the writ court order. What is there? Show us that what opposition did they file? Your appellate authority order is at page 72.
Appellate authority, Lordship. No, Lordship, that order supposed not to be
Page 59. This is the appeal. Appellate order is 11th August 2018.
Supposed not to be, Lordship.
No, this is that name order. Where is the appellate authority order?
That's supposed not to be annexed, Lordship.
That has not been annexed. Acha, now take what was their opposition? Page 77. What did they say?
They denied, categorically denied and disputed all the points only on the basis that I am not belong to the central list, Lordship. in page 80, Lordship, the authority specifically mentioned that, however, the Staff Selection Commission acted on the basis of the caste certificate submitted by the petitioner and recommended to Shasastra Simabal as found suitable for the post of constable.
Where you are reading?
Lordship, 80.
Second paragraph.
First paragraph.
Appellate authority's order was in the writ petition.
Was
It was
there?
annexed. If I can assist your lordship.
Yeah, we will come back.
In the writ petition, page 93. But in the paper book, it has been omitted.
Let us come to the order then. Now, what his lordship has observed.
That is from Lordship, page 106.
What? Kind of. 16. 207.
Second order.
জায়গায় এনেছি। হ্যাঁ, তুমি কোন জায়গাতে? So where is that order of the authority does not belong to central list?
The initial order, Lordship,
No, when the certificate was sent for verification, where is that order? Where is your but when the certificate was sent for verification, so internal page 80.
show code.
Where is this 14th of February 2017 memo? Yes, Mr. Bajpayee, 14th February 2017 memo.
Lordship, that is not annexed with the
Supplementary affidavit.
supplementary.
I have filed. That is
Supplementary. Wait, put it down.
in terms of your lordship's direction. Filed. And 1412 application is there. That is in page 5.
Page 5.
Page 5.
এবারেই প্রসিড করছি। এটা কোথায় বলবো? What is the rule referred to? Rule 23 of the rules means which rules?
For the armed forces, army.
My lord is asking.
Page 182, court said, paragraph 24.
Yes, this is the finding of the learned single judge. Is that appeal has been preferred.
8.
182.
That's right.
You please put your that.
Army Act,
No, Soros. This is
of the said rules. Which is this?
hey, suppose you
মেমোরেন্ডামের ওই ক্লজটা ঠিক আছে।
আপনি আপনাদের সশস্ত্র সীমাবল একটা আছে আমাদের একটা নামবে আপনি কতগুলো বই আছে সশস্ত্র সীমাবল আছে নিয়ে আসবেন। এটাই হবে।
Yes, what do you say, Mr. Bajpai?
Lord, you kindly see the appointment what my learned friend is submitting the letter of appointment.
That clause is there.
Yes.
That clause appointment is provisional. If the verification
No, in clause 12, my lord, the appointment is provisional and is subject to verification of scheduled caste, scheduled tribe candidates. That is done only at the point of completion of training. When they are sent to training, then the original documents are verified, the authenticity of the documents. And at that point of time, this was detected that the caste certificate has not been used under the central list. And my lord,
is that requirement in your notification which you have annexed?
Yes.
That is at page supplementary affidavit.
Yes,
Page 25.
yes. Page 25 is the notification, employment notification. My lord, that part, your lordship
In
will find
reservation
in
must
page
ensure they are entitled.
63.
They should be in possession in the format prescribed by government or in support of the
Yes,
government of India.
yes. On the basis of that format, it fell from your lordship.
No, it is page 51 or 48 different books.
On the basis of that format, it fell from your lordship that and my learned friend prayed for leave to submit the application form. But deliberately, he was aware that he needs central. He should belong to the central OBC category. That's why, my lord, he deliberately kept it blank.
এটার সাথে তুমি পেজ 51 টা দেখো।
And this is rule 23.
এটার সাথে পেজ 48 নিচে।
This is rule 23, as it appears from the order sheet that
Rule 23 of what?
of the Sashastra Simabal, where the petitioner was working provisionally.
Oh, আচ্ছা।
To be put by OBC for apply. The application form for a certificate for eligibility. It's an application form. So they should be in possession of certificate format prescribed in support of their claim. When copies of the certificate are reopen quality.
And that's a good
Where in your notification, staff selection commission notification,
yes,
we find that, have you found out that he has to be an OBC from central list?
No, my lord, the question is, my lord, I explained it earlier also, that the central government list, since central list and state lists are different, so that was prepared only for the purpose of employment either in the state list or from the state
Here,
list.
that is staff selection, page 25. কেন করবে?
Page-
In the staff selection committee notification,
Yes.
have you found any clause that it has to be from
Yes, yes.
central list?
In clause 4,
Yes.
candidates seeking reservation benefits of SC, ST, OBC, ex-servicemen must ensure that they are entitled to such reservation as per eligibility prescribed in the notice.
Hmm.
They should also be in a position of certificate in the format prescribed by Government of India.
Hmm.
So in the format, they should apply that is for the central list candidate.
That is page 51.
That is 25.
Page 51 of the supplementary evidence, format or certificate.
Yes, that is page 51. Yes. That is page 51, and this
51 nowhere says that it has to be, where is your certificate?
It is annexed at page
no,
37,
certificate of
37 of the paper book.
This Mr. Bajpayee, page 51, where do we find that
Page
this is a
51.
format that it has to be from central list where it is stated?
Page 48. Your Lordship, kindly come to page 48. It is clearly written at serial 8, serial number of
Page
the class,
48,
page 48 of the paper book.
not paper book. Your supplementary evidence.
Supplementary affidavit, my lord, it was directed by your Lordship, my lord. Your Lordship.
Kindly come to page 51. এগুলো সবই রেজলিউশন দেখছো না, সেগুলো সবই হচ্ছে কিন্তু সেন্ট্রাল গভর্নমেন্ট।
Yes.
গভর্নমেন্ট অফ
দেখেছি করেছেন
maybe order. The present writ petition has been preferred. The present appeal has been তো ওনাকে
ওইটা
2:10 বসছি না এইটা কি এটা সাথে ছিল?
13th March, passed an order. This is different. Different. দুটো আছে, দুটো আছে, দুজনকে দুটো দিতে হয়।
Or before the matter is taken up, can I may I be permitted to mention a matter?
What?
My lord, before the item of one is taken up, may I be permitted to mention one original signed matter, my lord? And this is appeal from order of execution, my lord. And appeal from an order of execution, my lord. This is specially assigned matter, my lord. I mentioned this on previous occasion. I was instructed that the matter will be appealed on 17th. Somehow I did not, and even today it is not in the list.
Yes,
May
that is because today we have fixed this matter to come.
My lord, may I hand over the one for inclusion?
Are you mentioning about notice?
Yes, I am mentioning upon notice, my lord.
নিয়ে নাও তাহলে একটু মনে করিও, একটু সাহেবের সাথে কথা বলে নিও না। কোনদিন বলছেন?
Kindly see the order dated 13th March. Second page, paragraph 8 and 9.
You have filed the opposition?
Yes.
In that matter?
Yes, yes. Conclude. So I can conclude my submission within 10 to 15, very short point involved. Let my learned senior friend, Mr. Bandhopadhyay.
Where is Mr. Banerjee?
Mr. Bandhopadhyay, in the morning requested
He said that
In 10 minutes I shall conclude my
but
lecture.
he
Very
is
short.
now his legs on point number 3 at 2.
We can take note, my lord. My learned friend is also appearing in this matter. Very short point involved. Original.
Your lordship pleasure was both the matter can be taken up.
But then the interim order is expiring, na?
No.
Yes, yes.
This is up till end of April. So if we cannot finish there has to be an
That I cannot stand in the way.
Very short point involved, my lord.
For the month of May allocation, I have been also received. Mr. Sarakaran also received.
Received for?
Allocation for the month of May.
I have not received. Only up to April. Paragraph 8 and 9. That is the record.
Submits allocation of PDS commodities for March and April has been made in
Your
favor
lordship
of
may
the
dispose of the
applicant.
matter within very short.
Wait, now let us understand. The allocation for the month of May would be allotted to you.
I also received. Mr. Sarakaran also received.
That is for March and April.
May month also.
I have.
I am appearing on behalf of the state.
Yes.
In our affidavit, we have indicated that Mr. Bandhopadhyay's client, who is now being represented by Mr. Dhara in his absence, he will be receiving from the month of May for distribution.
Not my client.
Excluding 8 distributors.
Excluding?
8 distributors. There are 31 in total.
No, Mr. Sharai, you.
I have received only
up
March,
to April.
April. That's the case of the state also.
Very good. For the month of May,
according to them,
how did they receive in March and April then?
They have
I have not
March and
received
April. March and April.
I have not received much.
May onwards, from the
Since
month
there
of
is no interim order.
Yes.
So I can call. This is a separate issue, my lord.
No, but read petition, in the read petition, same point involved.
Absolutely not.
We said that as the main matter is being taken up,
Yes.
we will hear it.
Issue is entirely separate. If you actually allow me just 5 minutes, I can show. In this case, what's happened, I am still now enjoying an interim order. Till now, I am enjoying an interim order. Read petition is still pending.
Which one?
This so far original side matter is concerned.
You did not get any interim.
I got an interim order.
In appellate side matter. In appellate side, his matter is appellate side. Appellate side matter point.
Wait, let us understand now. Yes,
I
original.
filed a writ petition in appellate side challenging the vacancy notice. An interim order has been passed. Till disposal of the writ petition.
That is which one we are hearing in appellate side.
That matter is not appearing in the list. That is writ petition. Appeal has not prepared. Against that, no appeal has been prepared. During existence of the interim order, a fresh writ petition has been filed by my learned friend client in original side without making me party, saying that interim order is not there. Accordingly, the learned single judge passed an order directing to grant the license. License has been granted. All is behind our back. Then we challenge the order, and your lordship heard this matter.
The license was granted from which date?
License has been granted in terms of the learned single judge order,
So
where we
that
are not
way-
party.
You mentioned that to us, that is why urgently it was taken up.
Yes, yes.
Then the state came and said that you need
Up to
not worry
April,
for
allotment in my favor. From May, allotment is in favor. So accordingly, your lordship refused to pass any interim order with the
Right.
desire that the
But-
matter will be heard within April.
Yes, yes, we remember, but the issue as regards the circulars which you are arguing before us in the appellate side, if that is decided, then there will be no litigation so far as this petition
Yes,
is
well,
concerned.
subject to lordship.
Will you keep quiet, sir? Yes.
Subject to lordship concern, this appeal only point involved when there is an subsisting interim order in a fresh writ petition.
Mr. Sarai, why you are arguing that? We will hear you in this petition also. Let him conclude his submissions on that. He said that I will.
From May, I will not be given any allotment.
Yes, unless we intervene. Unless we intervene.
As you
Yes, so suppose today he does not complete his argument in the appellate side matter, we will keep this matter next week for the purpose of your
That's what.
consideration of your interim.
I'm grateful. I'm grateful. Then I have nothing. I'm grateful.
Yes, tell us, where is Mr. Bandyopadhyay?
Sir, Mr. Bandyopadhyay is still engaged in code number.
Then what we have to do? Tell
Then I
us.
can proceed.
Huh?
I can proceed. लेकिन मैं can make a short passover.
Passover means we fixed it specially.
Then I start. Ma'am.
Acha, you tell us about this matter. Wait.
My lord.
If I'll take it off.
Your lordship, kindly come to page 40 of the stay application. Not so legible, it has been quoted subsequently. This is not so legible.
Yeah, just.
Page 40 is the stay application. The vacancy declaring notice notified on 1st of September 2022 for appointment of MR distributor at block Raiganj, subdivision Raiganj in the district of Uttar Dinajpur at page 40. 1st
Yeah, just
September
one.
2022.
Yes.
Page 40 is the vacancy declaring notice for appointment of MR distributor in my operational area, which was under challenge in my petition filed in the appellate side. Page 40. It is not so legible, my lord. Kindly see the date, 1st September 2022. Middle portion box, location, block Raiganj, subdivision Raiganj, district Uttar Dinajpur. Have you got it, my lord? Now I have challenged this order at page 46. An interim order has been passed by Justice Joyashin Gupta on 19th of January 2023 at page 46. Lordship, kindly take note of the first paragraph. Heard the learned counsel for the parties. It is pointed out on behalf of the learned counsels for the parties. Kindly take note of. Learned Advocate General was also represented through Shishana Bandyopadhyay. It is pointed out counsels for the parties that the same issue is being deliberated upon by a division bench of this court on MAT number so and so. The next date in that case has been fixed in the month of February 20. Well, this is a submission. Kindly take note of. Second paragraph. Let this matter come up for hearing so and so. The parties shall be at liberty to file written notes of argument. In view of the point taken, my lord, kindly take note of. This is the observation of the learned single judge. First paragraph is the recording of submissions up by petitioner that under the central contract 2015 there is no provision for MR distributor. Let the respondent not only finally appoint any candidate in respect of the vacancy notification in question. However, they shall be entitled to otherwise matter. But this interim order is until further order. There is no restriction. First paragraph only submission has been recorded. Interim order until further order or till disposal. State has accepted the position. Kindly turn to page 45. But approval has been given in favor of my learned friend client, but with the rider that unless the writ petition is disposed of, we cannot grant you license. Second paragraph, page 45. So, my lord, state also accepted the position. Till disposal of the writ petition, there will be no grant of license.
This was passed on 8th of June.
My lord, 8th of June. Then my learned son client filed an application on additional party in my writ petition. Now, your lordship kindly term, in the meantime, a fresh writ petition has been filed without making us party in the original site
by
his client. In that matter, page 48, your lordship kindly turn up. An order has been passed behind the back of our knowledge on 18th of January 2024, which will appear from page 48. Kindly see. No, page. Sorry, my lord. That is page, my lord. Page? 106. Sorry, my lord. Excuse me, sir.
So in this
100, page 100. You'll also kindly turn to page 100. It was given understanding that the writ petition, there is no pending interim order. Kindly read page 100.
This to issue license means on the strength of the license already issued. Page first memo which you showed us.
That is approval letter, not the license.
Page 40.
This is approval letter, not license. Kindly see. Second paragraph. License cannot be granted till disposal of the writ petition. Page 45. Second paragraph.
No, then what was page 40?
Page 40.
That is the notice of vacancy.
Vacancy notice. Vacancy notice. Which was under challenge. Which was under challenge in our writ petition, and in that writ petition, an interim order has been passed till disposal of the writ petition.
So this notification is in terms of 2013.
In that case, my lord, issue is same.
Oh. Very
Now,
good.
your
Now
lordship,
in their writ petition, what order was passed?
page 100. Understanding is that there is no interim order. Since the appeal which has been relied on at the time of hearing has been
Where do we find that?
page 100.
Instant seeking
The
direction.
instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of the vacancy distributorship block Raiganj under subdivision Raiganj in the district of Uttar Dinajpur. It is the case of the petitioner that the deputy director so-and-so issued a memo so-and-so. That is page 40 has been quoted. Second paragraph, your lordship kindly see page 100, the quoting portion. But in view of the interim order, High Court in matter of so-and-so, this is my client's petition. The state of West Bengal and others license in favor of the appellant shall not be issued till disposal. They have accepted the order. Last line of page 100, that has been quoted. It is the case of the petitioner that an interim order was passed in view of the pendency of the appeal. Well, this is not correct. My writ petition interim order has been passed on the basis of the submission, not consideration of the pendency of appeal. At page 45, I have shown to your lordship, submission has been recorded on behalf of all the parties that an appeal is pending with the same issue. There was no direction that the interim order.
So in that appeal, did you get any interim protection?
That appeal has been disposed of, keeping all points left open.
Disposed of by saying?
By another division bench. In respect, that appeal was filed by me with the application.
You filed that appeal against?
A separate order, entirely a separate issue. In that appeal, one of the point was 2013 control order. The learned division bench, honorable division bench, kept that point pending. I shall show you, I have annexed. Kindly see, my lord, in this, I have not been.
Mr. Because it is expiring, we will say that protection will be there till we hear this petition.
Your lordship, my learned friend argument.
Oh, no, you cannot.
No.
No, you have to leave it upon us.
No. That after hearing us.
No.
After hearing us.
Yes, but your submission was not that. Don't say no to the court. Court,
I'm
no.
sorry. I'm sorry.
Yes.
My learned senior friend says.
So you want to urge on that issue as regards interim order?
Yes.
Very good.
There, my learned friend.
Very good. We let him hear. Yes, next. Yes, Mr.
My lord, kindly come to page 101. I am reading, my lord, first paragraph. In this case, the petitioner that an interim order was passed in view of the pendency of the appeal being emitted so and so. That has been quoted in my interim order. Mr. Swanso, learned senior advocate appearing on behalf of the petitioner submits that there is no embargo to issue license in favor of the petitioner, as there is no such interim order for issuance of license in favor of the petitioner. Mr. Swanso also fairly submitted that by virtue of a direction of batch of petitions, an appeal being Samna Swanso was deferred before the Honorable Division Bench, wherein an interim order was passed by the Honorable Division Bench for not dealing any dealer from distributors. Mr. Swanso submits that the present petitioner is not a party to the proceedings, so the interim order passed by the Honorable Division Bench in Swanso is not effective. Mr. Sonal Sinha, learned counsel appearing for the state respondents, submits that the authority concerned has already taken a decision for issuance of license in favor of the petitioner, so necessary order may be passed. Having heard the learned counsel for the parties, it appears to me that the impugned memo dated so-and-so specifically restrained the petitioner from issuance of a distribution license by virtue of a pending interim order so-and-so. But this is also wrong findings. The interim order passed by virtue of a bench of appeal being emit number so-and-so. The appeal was dismissed and the disposed of by right order dated so-and-so. Thus, there is no legal embargo to issue license in favor of the petitioner. The petitioner is not a party to the appeal being emit number so-and-so. Under the above observation, the instant writ petition is disposed of with direction upon the concerned authority to issue license. My writ petition is still pending. Interim order still exists. I now show to your lordship the order of the Honorable Division Bench. Page 40, 48. Which has been said, my lord. Page 48.
This is appeal against which?
Yes, this appeal against an order, entirely different issue.
So, no, this in his order, there is a direction, interim order will not. His interim order was disposed, his writ petition was disposed of without directing to issue a license in his favor.
Not disposed of. Writ petition is still pending.
This is pending.
My writ petition is still pending.
Not your.
That writ petition is disposed, my lord. My learned
In
senior,
which you have not been a party.
I was not a party.
Your lordships have observed on the day that before 30th April matter would be decided, therefore the interim order is there.
So, Mr. Bandyopadhyay, we said that, but if we cannot complete the hearing.
Just 1 minute can I just be permitted. After 30th April, allotments have been made in his favor and also in my favor.
No, he says that it has not.
No,
been
that's possibly state will say.
State also saying
State
that.
has said.
Allotment to state or favor. Allotment has been made.
Very good. There will be a status quo then. Mr. Bandyopadhyay.
Status quo means what? Status quo means the allotment has been made. Thereafter, I have to leave the goods. If your lordship passes status quo, then how can I leave the goods? Leave to goods. So I have to leave the goods.
My specific
don't
instruction, I have
understand
not been allotted.
Allotment has been given to both the parties.
Out of 31, 8 have been given from May onwards. We have withdrawn 8 and we are giving to a learner senior friends clients.
Out of 31,
31. 23 are still remaining.
Absolutely
no,
not.
31 is the total number of.
31.
My learned friend take fresh instruction, my lord, over telephone. My specific instruction today morning for May, I have not been allotted a single quota. An entire quota has been given to my learned senior friend.
No.
That's my instruction. That's fine.
So if the
From
quota,
May, I will not.
if the quota which we are enjoying this month, that much is given to you, you have no problem.
No problem.
You are in these 2 months, you are having quota of
8 dealers.
April
8
must be
dealers.
for 12.
8 to 12
out of 31.
Yes. They will get, my lord,
আমি
23.
কোনটা?
Oh, they will get 23.
কতগুলো দিয়েছে?
They will get 23.
আমি তো অজিত কুমার কুন্ডু
So
একটাই
this,
তো।
madam, this 8 has to continue with him. You have given how
Full time
many
থেকে 8টা
to them?
কেটেছে।
হ্যাঁ। My lord, I kindly see this allotment I have given. Out of 31, 8 allotments have been given to me. So far, kindly see.
Yes.
From one Ajit Kumar Kundu, I have got 12. From Manoj Kumar Mitto, that is his client, I have got 8. And from Raya Enterprise, I have got 10.
8 has been detained.
That comes to 12 and 8, 20, 30.
Yes, 30. From different. So far, his case is concerned, only 8 has been taken.
So from him, only 8 has been taken. And he's.
I'm existing distributor. I'm running with no, my lord. Now he has argued for 3 days existing.
No, not in this matter.
My lord,
We are constrained to take up this matter since we are not being, the earlier matter was not concluded.
Correct, my lord. Your lordships have said that the all matters will be concluded. That's my lord. I gave consent. Kindly see, I gave your lordships consent. On the last day when this interim order was passed, I gave consent up to 30.
Not pass any interim order, Mr. Bandyopadhyay. We said that since we have been apprised that till the month of April, the situation will be, month of May, allotment will be given. We said no interim order.
That's I made from. This is from the month of. It is from the month of May. Allotment is made for the month of May.
31 dealers out of 31 dealers, 8 have been tagged with
of
you.
the month of May 2020.
Today, as the situation stands, 8 is remaining with you out of 31.
I have existing 31 dealers tagged with me.
23 you are enjoying.
Oh, sorry, my lord. 23 I'm enjoying. I had 31.
So out of 31 dealers,
8 have been dealing for the month of May.
So
now it appears he is getting more dealers than me. That doesn't
can't be your
but in terms of an order,
can't be your
no, I'm not wrong.
So, Mr. Sarai, if 23 dealers allotment is made in your favor, you will not have any problem.
Definitely, this 8 should not be dealing because there is an interim order till today.
The 8 has been delinked and given to him.
It cannot be.
That will be done from the month of May.
Yes, from the month of May. From the month of May. All together, I am getting 31 dealers for last 10 years. By virtue of an order passed in an ex parte interim order, license has been granted and 8 has been delinqued. This curtailment.
Where is that delinquent order?
What is
there
that?
is no delinking
That,
order.
that is the my learned senior friend has position. I have not been given. I have not been given copy. I have not been intimated.
State must be having that.
No, this is report they have submitted earlier, page 13.
Of which report, Mr.
এই তুমি বলো না ভাই, তোমরা কেউ বলতে মুখ দিয়ে কথাই বলতে পারছো না তো। সেটা অ্যাপ্লাই করতে মুখ দিয়ে কথা বলো কিছু।
Which has already been placed before your lordship.
একটু কথাই বলতে পারো না কোর্টে এসে। Kindly see page 13. This order was passed, my lord, now in. This order was passed in 12th February 2025. সেটা বল না, সেটা তো জিজ্ঞেস করছি।
The following
সেটা কাগজ করবে।
Here discharged. Oh.
But there are 2 appellants.
This is no, এটা তো 30th January. আচ্ছা।
Now, my lord, kindly see now.
Just following is hereby detect from 4 distributors. এর নামটা কি জানো? Roy Enterprise.
অর্ডারটা কোথায়? অর্ডারটা কোথায়? জজ সাহেবের আগের অর্ডারটা কোথায়? সেটাও তো আনিসনি।
এ হচ্ছে তো জয় এন্টারপ্রাইজ। রয় এন্টারপ্রাইজ। রয় 10টা দেখছি তো। Have you got a copy of their opposition? State opposition? Kindly come to page 13. This is issued on 12th February 25. You are Roy Enterprise, na?
No, I am 2 appellants, Roy Enterprise and Sujata Mitra.
No, here in this memo, Sujata Mitra is
Manos Mitra, my lord. Manos Mitra, one of the partner. Sujata is one of the partner. Page 13. Sujata is nowhere. Sujata is only namesake.
So from Manos, 8
Kumar
has been
Mitra and
detected.
Sujata Mitra is the partners. Sujata Mitra filed the appeal.
Very good. From them, 8 has been detected.
Yes, from Sujata 8 have been dealing.
And from Roy, 10
have been dealing. Roy is not his client, and
Roy is also a petitioner.
Appellant.
Appellant.
Roy is the appellant in where?
In this appeal?
কোন appeal Roy is also here. Roy is also different. Now, this is different. This has been issued on February, not challenged. Not challenged. Now, on the up to April, your lordships have passed the order.
Not challenge means it was Justice Shubhendu Adhikari's order was, sorry, Shubhendu Sampanto's order was challenged before us. This
Well,
way,
I am saying this order was not challenged anywhere.
The product of the order of justice.
This order was not challenged.
this order is consequential to Justice Samanto's order.
Correct. Now I am coming, my lord. Let me make it short, because if I go on his basis, matter will never end. We continuing hearing. Like a mandamus, continuing hearing. This order, therefore, after your lordship passed the interim order up to 30th April.
We did not pass any interim order. We passed that we have said that no interim order we are passing, since the state submits that up to 30th April, there will be no detachment.
Very nice. Now, I'm sorry, I am just amendment. I'm very deeply obliged to your lordship.
What you are wanting to see?
Now, my lord, I want to say, on the basis of this, state said up to April they will not give it. From May, goods have been allocated and I have lifted.
For May, you have lifted?
Yes. I have lifted goods.
So this order has been given effect to according.
This order has been given effect to for the month of May. In every time is any allotment is made before 1 month ago. In the meantime, goods have to be lifted. I have to distribute from 1st May. Up to April, I have not lifted, since the state has not made any allotment to me. State has made the allotment.
Lifted for the, you have not lifted for the month of April.
I have not lifted. I have lifted for the month of May. Now we are April. Next month is month May.
Lifted in the sense, what is the procedure?
Lifted from the state government. Distributor, we have to take it from the godowns.
Then it has to be distributed.
So this they have lifted.
Yes.
তাহলে এর বাকি কত থাকবে? তো 31 বলছে 10 আর 8
দুজনটা কি? Millard, if you're
Mr. Shara,
Millard, kindly come to your lordship's paragraph 8 of your lordship's order. 13th? 13 March.
No, madam, you explained to us up to April.
That has been made clear on that date itself. Kindly see paragraph 8 of your lordship's order.
Yes.
Similar paragraph 8. In course of hearing of the present appeal and answering our query, Mrs. Sina, learned counsel appearing for the state responsibility, submit that allocation of the PDS commodities for the month of March and April 2025 has been made in favor of the applicants, and the allocation of PDS commodities for the month of May 2025 onwards would be allocated to Sujan.
That would be allocated.
Would be allocated.
As such, we by
let the written instruction as produced be kept on record. In view thereof, question of issuance of any further interim order does not arise. Therefore, it was made clear, it was informed.
It will be given effect from May.
May.
Yes.
Therefore, your lordships have not passed order. No order because of the April allocations have been made in their favor.
Yes. So there was no detachment when we heard the matter on 13th March 2025. When we heard the matter on 13th March 2025, there was no detachment.
You have kindly come to this is a page 12, February 2025, the report.
We have seen that.
That's 12.
That
allocation
order was
has
passed.
been made to me from month.
This will be given to you from the month of May.
That goods have been given to me already.
But how the goods can be given to you if you have not allocated?
It is practiced to deliver the goods before 1 month.
Yes, what is the system?
allocation is made 1 month back, so that the distributor can lift it from the state godown, store it in his godown, and distribute it in the month of next month to the dealers. In this case, what happened, since your lordship considered the matter that it would be decided prior to May, recorded in the order that up to April my client is protected. And observation was that it should be disposed of prior to May. Accordingly, my lord, an order has been passed, allotment has been made, but it has not been lifted. Kindly consider at that material point of time. At that material point of time, when your lordship passed the order, there was no lifting by my learned senior friends client. Goods were in the FCI godown. Since matter has not been heard during the disposed of, they lifted the goods, stored in their godown, but not distributed to the dealers. Distribution should be start from the month of May 2025.
Now, once they have lifted, then if we intervene, then the goods will be destroyed.
I shall be given.
So it will be given back to you.
Yes, I have made out a case. You also kindly consider this matter.
So why didn't you tell us that on the 13th of March? 13th
That
of
I have
March.
submitted. That I have submitted. Your lordship may remember on that I have categorically submitted.
13th of March, you said that when allocation is for the month of May, no problem. That is why
I have
we
not said.
recorded.
Kindly consider. My learned friend, I have not submitted. I have repeatedly paid for an interim order. I have repeatedly paid for an interim order. Status quo. Yes. Repeatedly paid for your lordship observed that since you are protected until April and we are in a position to dispose of the matter by April. So
we have not said that. We said that it is interlinked with another matter. If we dispose of that matter, then the problem is.
Dispose of that, but I shall not take 10 minutes.
You could have told us that there is a possibility due to this order, they may lift the goods. You could have told us after 13th March.
That I have submitted repeatedly. My lord, kindly protect me by passing an interim order. Kindly consider. I have repeatedly, my learned senior Mr. Mitra also submitted. Please pass an interim order. Also, Mr. Joydeep Kaur. Your lordship, kindly take note of.
Thereafter, in your presence, we said that don't pass on the buck to the bench.
I am not passing.
That is exactly what you are saying.
Till I am protected.
Till April,
I am protected.
Now the goods have been lifted. You are saying we in between 13th of March.
This is usual practice. I shall lift the goods from there, go down in my cost. In my cost. Record it. That's the usual practice. If any distributor is suspended, stocks are with them. The nearer distributor lift the same and store it in his godown. It is the usual practice. Unless it is distributed, no right acquired. It has not been distributed to a single dealer. Or your lordship, kindly dispose of this matter first.
No. Why dispose of first means? Dispose of first means?
By suppression of material facts, concealing of facts.
Suppression.
Making me this order has been obtained.
By making fraud, you have obtained the order, which have been said to the court. Making fraud.
You did not tell us also on that date that if 13th.
No, it has been said, lordships have recorded that. Lordships have recorded that.
We have recorded that this factum of lifting. Now today, they have lifted the goods. Now, how from the month, if we do not finish off this matter? Yes, what you are saying?
One humble submission may I make? This is an ongoing process, your lordship. In my affidavit, page number 5, kindly see.
Page number?
5. Paragraph.
Yes.
Accordingly, 31 FPS dealers have been de-tagged. We have never, on that day also, when that matter was taken up and when I had submitted my instructions, a few page instructions, that in that page also, it is taken on record that it has already been de-tagged from the month of February. Only the distribution, lordship's distribution, which he will distribute to his dealers, that will commence from the month of May.
But he has already lifted the...
This is the process, your lordship. This has to begin given 1 month in advance so that they can take it and then distribute it among the dealers. Now, I don't know my learned senior friend what he wants to interpret and show to your lordships, but this is the regular process that we have been following and we have been doing. So this is according to strictly in accordance with law. Now, where does this interim order, scope of interim order and status quo come from? I have no knowledge, and I have a limited scope in this petition which is being argued before your lordship. So this is, and on the affidavit also I have categorically explained in this paragraph, page number 5, that it has been detacked in the month of February itself. Only the process now, which my learned senior friends, clients will do, is distribute from the month of May. That is all. And this was given by way of instructions to your lordship from that day.
My lord, kindly see one thing. My lord, can I just proceed? For his allotment month of March, it was given in the month of January. Similarly, it is going on 1 month before. So far May is concerned.
So now then, after deduction of this, from one you have deducted 8 and from another you have deducted 10. From this we find. So how much is remaining with him?
So for appellant number 1 is concerned, 23.
এটা হচ্ছে এখন লেটেস্ট দিস ইজ হাউ ইটস
মানে একটি কি ষোলো কি করে এর থেকে 8 গেছে, এর থেকে 10 গেছে, 18 গেছে, বাকিদের থেকে আরো 12 গেছে।
এই যে 8 কমে গেছে এসছে একটা মামলা করতে উজ্জ্বল এর 3টা পেয়েছে।
Last day, your lordship said that I would finish this argument in the main matter.
We will, Mr. Bandyopadhyay, but we will have to solve this issue, na?
All right, my lord.
This modification. Mr. Sujata Mitra, তাহলে এখন 23 আছে।
Is this correct? Sujata Mitra now has 23 dealers. Roy Enterprise has 28.
No, 30 minus 10, 20.
30 minus 10, 20.
My lord.
And Sujon has 31.
So far, my lord.
31.
My 31, so far my vacancy is concerned.
So we have been reduced.
No, that is really because of the vacancy. That is which are related with the vacancy. Not, it is not a case of a comparison. I am 20, 30 or 31. The vacancy was that is 31 is connected with the vacancy. I have reduced 1, I have reduced 3, I have increased 5, all for just to mislead.
From this 31 is coming.
These
Last 10 years, I am running with 31.
31 because of the age.
Which?
No.
Right.
There are other 4 distributors where from they have also dealing. No. 31 comes.
No, presently, how many dealers are with you? 23?
I am concerned.
Huh?
31 dealers from last 10 years.
Now 23. After that tagging, how many?
23.
23.
So you are having 23 dealers
today,
and today you are having 20 dealers.
Super Roy.
So far, Roy is concerned.
So that this 23 which you are having and 20 which you are having number 2, in respect of you, you will be permitted to leave the goods.
No, yes, I lifted the goods.
So far as Mr. Bandyopadhyay's client is concerned, pursuant to the detachment order, the enjoyment which he is now enjoying, we can restrict that enjoyment till we hear the matter. Finished. Now you are saying that I have not yet been given those 23.
No, 23 altogether with me.
So we are recording that after this order was passed, the effect had been that 23 are remaining with you and 20 is remaining with Rai and 23 is remaining with Mitro, and now presently he is enjoying 31. This situation will be continuing till we...
For that matter, no order is required. For that, no order is required. This is permanent tagging. This is permanent tagging. I came before your lordship with the appeal saying that during existence of the interim order, during pendency of the writ petition, whether license can be granted and subsequent steps can be taken. Lordship decide the issue, pass an order, I will not be harmful.
Very good. Then we will finally decide along with this matter. You are saying 23 and 20 we will record.
That is not recording is necessary. That will also
then Mr. Then Mr. Sharadai, what you are insisting?
I am insisting that I was under impression that since I have been given total to 31 and 30 till the month of April, and which has been recorded by your lordship also in the order, that we are not going to pass an interim order since I am protected till April. Kindly take note of.
This thing was not made clear to us because this was passed in your presence. It was
We repeatedly
pointed out.
submitted before lordship.
You said pass an order of status quo. You said that let there be because the matter was
Status quo.
mentioned.
On that day, that has not been lifted. On that day,
Mr. Sarai, we ought to have been apprised that due to this problem, but whatever it be, need not go into this issue. If you do not want that is to be recorded, so very good. We will proceed with the hearing with the main matter as well as this matter, and we will conclude.
So so far this matter is concerned,
This matter is concerned, we can do this much. We can say about you are saying that during pendency, we have been shown that this has been issued. 23 dealers are still with you and 20 dealers are still with the number 2. Supplies pertaining to these dealers will not be disturbed till the matter is heard finally. You said that is not required, that is a permanent attorney. Very good then. Then we are not passing, we are hearing Mr. Bandyopadhyay.
for the appellate side matter is concerned.
This also we will hear then, Mr. Sarai.
So in that case, my lord, may I conclude my submission so far original side matter is concerned?
As we fixed it today for him, let him conclude on this. If he cannot finish, we will not let you go. It is not a case that
May I
we-
submit one thing? Let him conclude his submission in the original.
That's very good.
Let
Very
him
good.
conclude, but I hope he will conclude.
Mr. Bandyopadhyay, all of us are
understand.
making an
No,
endeavor.
no, I am.
You are making
we
an
are not.
endeavor.
I am not blaming your lordship's code. I am saying let him conclude. With folded hands, I am saying let him conclude.
Mr. Shirshanno Bandyopadhyay has completed.
Yes.
Yesterday.
Let him conclude. Milord,
Yes,
may I,
Mr. Shah.
with your lordship, may I come back after 15 or 20 minutes because it will continue for some time. If your lordship just grant me leave, let him conclude. Let him conclude once. Whatever he wants to, because whenever I will be. Just the vacancy notice.
It was assigned বুঝতে পারি ছোট ঝামেলা জিনিস রয়েছে
But page 40 is a vacancy notice. But I will just get 15 minutes.
already খারাপ yes tell us page 40
Original na, no,
yes tell us
page 40 is the vacancy notice. At location Raiganj, Uttar Dinajpur.
কেন কোর্টে থাকতে ভালো লাগে না yes tell us
At page 40 is the vacancy decline notice.
এই কার্তিক
লর্ডশিপ শুনতে
ওইটাতে
কথা
দেখো একটা নোট ছিল আমার ওই অ্যাপিলেট সাইড ম্যাটারটা ওটা তুলে হ্যাঁ একটু দাও
Another 2 minutes for statement.
yes
2 minutes. 2 minutes. My lord, just take it. 1st September 2022. 3 minutes gone.
page 40
40.
yes
A vacancy has been notified in my operational area with the proposal curtailment of dealers from my distributorship.
That you have explained to us,
Now your
challenging
lordship,
that you filed a writ petition.
Page 46.
Now writ petition, interim order was passed.
Till disposal of the writ petition. And first paragraph says only recording of an appeal. Only recording an appeal. Page 46. This order has not been passed relying on any interim order of the Honorable Division Bench. My specific submission. First part submission, second part observation, third part direction. Direction says interim order till disposal. No limitation. Whether appeal is disposed of or not, whether interim order passed in the said appeal is disposed of or not, it is immaterial.
So you are saying page 46 order was
The
not
independent order,
not dependent upon appeal court order. Yes.
I'm get close.
Yes.
Now your lordship kindly come to page 45. After passing this order, an approval has been granted with the rider that no license shall be granted till disposal of that writ petition at page 45. This is an order of 8th of June 2023. Page 45.
Yes.
Connection with the Fair Purchase Department number so and so.
Yes. Government memo.
Yes. Last 3 lines, second paragraph. Such view of the interim order of the Honorable High Court in the matter of WP number so and so. This is my repetition. License in favor of the approved applicant shall not be issued till disposal of the petition. State took it in terms of the court's order, in tune of the order.
However, without making a party, a writ petition was filed in which page 106 an order, in page 100. Now, after this, you preferred a review application.
That has been initially interim order granted, they dismissed with the observation, just one line. Appeal is lying. That is, you also will get my lord, page 121. Just for a moment, page 121. Now, the division bench, which has been dismissed, following the which interim order has been passed in the decision. Kindly take note of that order. What the division bench says. Page 48. With clear indication, all points left open. Page
48. This was an appeal preferred against what?
Which have been, my learned, that in that matter, I was also a party, my learned friends also party.
Monopoly.
No monopoly. No monopoly. Monopoly is there. But a company has applied, just to me, a company has applied for a distributorship. That application has been rejected on the ground that company cannot. My learned senior friends line moved a writ petition and order has been passed. Group of individuals means company, accordingly, your application has been allowed. In that case, vacancy was also notified in respect of my another client. I filed a leave to appeal application. Initially, I got an interim order. Ultimately, my leave to appeal has been dismissed with a specific observation that we are keeping all points left open.
So this is the order in leave to appeal.
Right.
And what happened to the parent appeal?
Entire leave to appeal goes, entire appeal goes.
Oh, achha, achha. This was registered as...
page 48, two paragraph I shall read.
So you were appearing in that matter for the person speaking for Shakuntala?
Shakuntala. The existing distributor of that area.
Yes, in this the court observed that all points...
Second paragraph, a leave to appeal was sought to. Then kindly turn to my lord, page 54. Page 54. Second paragraph. In one of the point was whether 2013 controller became redundant or not. That was one of the point. Page 54, second paragraph. Since no decision has yet been taken, the right of the appellant does not appear to have been infringed, and therefore the plea of person aggrieved does not appear to be sound and logical at this stage. The concept of person aggrieved originates on a principle that if an order are passed in a proceedings between the litigants affecting the right of third party who is not implicated in the proceedings, such third party may assail the said order before the higher forum upon seeking leave to appeal. The grip of aggrieved has to be judged in the context on the decision taken by the original authority or the court of first instance on the basis of the cause of action pleaded therein and the tenant of the ultimate decision. Merely a proceedings is litigated and the ultimate decision does not affect the right as to final decision has been taken. As in this case, the appellant cannot be said to be person aggrieved to maintain an appeal as person aggrieved. Pausing for a moment, the learned signatures directed to consider their application. So final decision has not been taken by the authority. Next paragraph. Since all the points were kept open, including the point of locus and having held to be so and so, the person agreed. We do not venture to decide the other issues. This is the issue in regard to redundant of controller 2030. Issues raised in the instant appeal, we have been given to understand the several litigation are pending in the docket of the court in relation to distribution system. This is my 2013 controller challenge. Within the state of West Bengal on various grounds, including the ground which have been taken in the instant appeal. Therefore, it would be appropriate to record that those points shall not be treated to have been decided by us in the instant appeal, impliedly or expressly. Since our judgment is restricted to locus of the appellant to maintain the appeal as person aggrieved, therefore all other issues are undecided and kept open, and it can be other proceedings, be it collateral or otherwise, shall not be constituted to have been impliedly decided. Now, your lordship, kindly take the order improving in the instant appeal. Page 45. What was the submission and what was the recording? Page 45.
46.
46. Kindly see. Read the exact order.
So this leave to appeal order was passed on
Only
18th January.
Yes. Thereafter, they filed an application for additional party in my pending writ petition, thinking that they have to vacate the order.
Page 46 order is prior to the appeal court order.
No.
Prior to the decision of the appeal.
Page 46.
46. Yes, yes, yes. Yes, but only recording. First paragraph, only recording. It is pointed out by the parties. That has not been taken note of. Not in terms of the interim order passed in that appeal.
In the appeal, was there any interim order passed?
There was an interim order initial.
In your favor?
Yes. But kindly see second paragraph, third paragraph, last paragraph, page 46. In view of the point taken by the petitioner.
Why you are so much stressing on this issue?
Because the interim order in the instant
So
appeal.
your point is an independent interim order was passed.
100.
On
Then workshop on second come to page 100. What was the findings of the learned single?
Page 100.
Page 100. This is the order improving in the present appeal.
Yes.
Instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of the vacancy resource. Then, my lord, the approval order has been quoted. Last line, the state has recorded that license shall not be disposed of, say writ petition. Have you lordship got the next paragraph? It is the case of the petitioner that an interim order was passed in view of the pendency of the appeal. Well, this is my submission. That interim order passed by Justice Joshua.
This is an erroneous recording.
Absolutely. They come on the basis of that order has been passed. Mr. Bandyopadhyay, learned senior advocate, appearing on behalf of the petitioner, submits that there is no embargo to issue license in favor of the petitioner, as there was no subsystem interim order for decisions of the license also.
So court proceeded on that basis.
Yes. My interim order is still pending. It is still pending. Again, I am repeating. Mr. Bandyopadhyay also fairly submits that so and so. Mr. Bandyopadhyay submits that the present petitioner is not a party to the proceeding. Then Mr. Sonal Sinha learned so and so. Then, having heard the learned counsel for the parties, it appears to me that the impugned memo dated so and so specifically restrained the petitioner from issuance of distributorship license. Is the approval order by virtue of a pending interim order so and so was passed by virtue of a pending appeal. Well, kindly take note of that interim order has never been passed due to the pendence of the appeal. The said appeal was dismissed and disposed of by order dated so and so. Thus, there is no legal impediment to issue license in favor of the. Is it the order of Justice Joshua Gupta that till disposal of the appeal, there will be an interim order? Is it the order of Justice Joshua Gupta that in terms of the order passed by the division bench, this interim order is being passed?
No, Justice Sengupta's order was not brought to the notice of.
Absolutely. Independent order.
Very good. Yes.
But these are my submissions.
Any other point, Mr.?
No, these are my submissions.
So this is limited to the issue on that.
So far,
Limited.
this matter is concerned. এটা পরে বলবো আগে আমার অরিজিনাল অ্যাপিলেট সেটটা আগে করব
That repeated, that
No, only appeal.
So
Only
appeal
appeal.
is
Whether
limited.
the order passed by Justice Samanto in original side matter is a proper order or not. That writ petition is still pending, interim order is still there. Due to pendency, during pendency and existence of the interim order, whether this order should have been passed or not. With the observation that there is no interim order. That's my only case.
So page 45 kindly come. Page 45, in terms of this government order, government said that shall not be issued.
Yes.
Disposal. License has not yet been issued.
Yes. In terms of Justice Samanto's order.
License.
Yes. And allotment. Everything. Only in terms of the order of Justice Samanto, which is a wrong order. Behind the back of our knowledge. Joyson Gupta's order still exists. Whatever going on today, my lord, allotment, distribution, tagging, all in terms of the order of Justice Samanto, which is under challenge in the petition. This is my case.
So what is your prayer in the writ petition?
Wash and set aside the order passed by the which petition?
In the
appeal.
Justice Justice Samanto has disposed of the matter.
So far, their writ is concerned.
Your writ petition is still pending.
Pending. Exists interim order. Till today. And state has affirmed an affidavit. Kindly take. They have also stated. Kindly take up the report. Just you have lordship has gone through it. 3B. Kindly take up page 4.
So, Mr. Sharda, if we hold against you in the appeal.
In this appeal? No. Main appeal.
In the main appeal, if we decide in your favor.
Everything will be correct. Absolutely.
Then there
no, only thing is that, my lord, so far this part is concerned, this license has been granted in terms of the order of Justice Samanto.
Yes.
Unless this order is interfered with,
yes.
Possibly, my lord, this order, this license will continue. Because your lordship cannot dispose of the order passed by Justice Joyson Gupta that is been still pending, no appeal has been prepared.
No, suppose in the appellate side, let us understand, the appellate side matter, if we hold in your favor,
all vacancies goes.
Then all the vacancy will go.
Those which have been challenged. In my case, kindly consider, it is still pending, no appeal has been prepared. Your lordship cannot touch with the order passed by Justice Joyson. Possible.
He's confused. He knows how to
Petition also.
Yes, that I can go before the learned single judge and showing that order, obtain an order that this vacancy also goes. That I can do it. Am I clear to your lordship?
I don't know how many other vacancies challenged or not. That is also is not clear to
not
us.
less than 100. But if your lordship settle the issue, all matter will be decided on the basis of your lordship's decision.
Yes, Mr.
No, just report. Just report what state is supporting my case.
Yes.
Your lordship said
within 15 minutes you will finish.
Yes. Oh, just yes. What
state is supporting? Kindly take up the report.
Yes.
Page 4, paragraph 3B. Paragraph 3B. It's a case made out by the state in this case.
Yes.
Page 4, paragraph 3B.
Yes.
Before issuance the license in favor of Sujan Chandra Roy, a writ petition being number 1, so that is our writ petition, was filed before the Honorable High Court at Calcutta, and the Honorable High Court passed an order in this matter, wherein it was directed to licensing authority not to issue the MR distributorship license in favor of Sujan Chandra till disposal of the writ petition. This is the observation. This is the findings. The till disposal of the writ petition.
We understood, Mr. Shah, right? That how you are taking contradictory stand.
Minor.
You are taking contradictory stand. Once you have granted me protection that no interim order, when in view of that interim order, no license will
Yes. Before
you
that,
are also when you are party to the another matter, you
when
are
the original side matter was moved, learned state advocate says we are going to issue the license. Kindly take note of that paragraph. Contradictory to the state statement. Kindly take up the order passed by Justice Samantra. See, page 100. This is very new thing, my lord. Page 101. What is the submission of the learned state? Despite this affidavit, last part, one paragraph. Mr. Sonal Sinha, learned counsel, appearing for the state respondent, submits that the authority concerned has already taken a decision to issuance of license to have the petitioner. How it can be? State's affidavit says till disposal of the writ petition.
All right.
But these are my submissions.
Thank you.
Can I start, Miller? Take the appellate side matter, Miller, which I was arguing.
May I just come back?
Yes. Now, Miller, I was arguing the point.
যে এইটাকে সরিয়ে দাও
Well, just one thing kindly take note.
এটা কার?
Well, just one thing kindly take note. So many arguments. Miller, before just I start, just take note one thing. The appellant in the original side here was not appellant in the appellate side matter. Therefore, interim order which was passed by the division bench in this appeal only covers
this appeal means
appellate side appeal, which is being strongly relied upon. This interim order,
he was not a party to that.
No, he was not an appellant there. And these interim order which have been passed in these appeals are covered only the appellants who are before your lordships. Because on that date, when the Justice, Honorable Justice Bagchi's bench, presided by Justice Bagchi's bench, passed an order that if licenses have been granted, it will continue with the licenses have been granted, allotments were there.
That was said by the division bench.
Yes, I will come to that. A division bench order to the interim order. See your lordships file. See your lordships file. And later on, division bench said, no, this order is only limited to these appeals, not to others.
Very good. He will show it.
We'll show to that. Now, let's come to merit of the appeal. Now, I was submitting to your lordships that he is a beneficiary of the 2013 control order.
Yes.
Because, my lord, kindly see the license. My lord, the order has been given to in his favor at page 288. Kindly come to page 288.
Yes, you have showed us that. 7th October 2010, 2021.
2021. And see.
No. What did you say? You cited 288. That is the
288. This is his first appointment.
288. You are from which memo yours?
This is the appeal. The appellate side appeal.
288. It is not telling with me.
Yes.
288.
288.
Yes, sir. So he has obtained dealership on compassionate ground, relying upon the redundant circular according
to him, and that too in year 2021.
Very good.
And application is that, and he is guided by the, kindly see second paragraph. You are directed to furnish the following documents for further in the matter of issue of provisional license, so and so, maintain control, the following documents should be submitted.
Yes.
Now, all the appellants before your lordship, all they are enjoying the benefits of the 2013 control order, still now.
So they are also on compassionate ground?
No, he is a compassionate ground.
Or
Now,
they are on different ground?
maybe compassionate, maybe
So
different,
all-
because I am not appearing since you are
All enjoying the circular of 2013. Control order?
control of 2000. Malad, kindly, just here I am telling you, just submitting 2015 control order, which he is relying upon. There is no provision for appointment on compassionate ground. What he is saying, 2015 control order.
That will harm him.
Madam,
That will go against him. Even if we hold that 2015, this is redundant, 2015 will apply. He will not get compensation.
No. Therefore, see, what he is saying, what he wants to do, he wants to keep it. Nobody should come. I will say 2013 control order is redundant. 2015 control order, I only will play. But all these 150 or those who are there, those who are filing in the writ petition, all are beneficiaries of the 2013 control order still now. Whether one can approve it and reprove it.
You are saying that it is an only intent to stall the
entire thing. He has said already 100 petitions are on the pipeline. Therefore, only these persons will control the entire West Bengal. No other persons will come.
Yes.
Now, my lord, I will show to your lordship very important provision. See, my lord, I will just come to your lordship. Kindly see. Kindly come to page 2013 control order. Kindly come, my lord, page 259 first. I am just on, sorry, let me clear that point first. Kindly come to, my lord. Page, sorry, my lord, kindly excuse me, page 175. Sorry, I will come to 175 first.
Yes.
Similar, clause 27. 175.
Yes. This is 2013.
Clause 27, your lordship, this is 2013 control order.
Yes.
Kindly come to, my lord, 27 clause 2.
Yes.
Every license is issued under clause 27(1) of this order shall be renewed up to 31st December next, subject to the satisfactory performance and confirmation of the distributor. And on receipt of an application for renewal in Form J and renewal fee as mentioned in Schedule B hereinunder from the licensee. Therefore, my lord, a license is valid for up to 31st December.
Yes, you said that earlier, 288, 1 year.
Why? Then he has to file an application for renewal. And renewal in the Form J. 175, your lordship has seen that the he has mentioned Schedule B. Thereafter, every license shall be renewed.
No, Mr. Bandyopadhyay, 288, it was 1 year, which you showed us.
Yes. This is all licensed for 1 year.
Where is that for 1 year? Do we find in 288?
Kindly come to page. Oh, this is an order.
Provisional license under 27(1) of 2013.
His license, first license is at page 49.
Maximum period of 1 year. Yes, yes.
27(1). Yes, 27(1). Now, my lord, kindly see, I have shown to your lordships that 27 Roman 2.
Yes.
That there your lordships will see
For
that
renewal, he has to apply in terms
under Form J.
Kindly see now Form J. Form J is at page 203.
Yes.
This is Form J.
Yes.
This is the Form J, application for renewal. See? Form of application for renewal of license for distributorship, read paragraph 27, Roman 2 of the WBPTS MC Control Order 2013. Therefore, his renewal application is also under 2013 Control Order.
Yes.
Today, he is enjoying a license under 2013 Control Order.
Yes, he's saying that you declared the yes, that will go against him.
2013 Control Order. I am coming, whether he can challenge at all or not. Point is going against or favor.
No, he is a beneficiary of 2000.
If one beneficiary of a 2013 Control Order, can he challenge 2013 Control Order? Can he approve it and reprove it?
He has not challenged. He has said.
Oh, he is saying 2013 Control Order is redundant.
Yes.
That is one of my point of argument. In your prayer, you have not said 2013 Control Order is redundant. I will show. Just give me time. I will come one by one, stage by stage. Therefore, he is a beneficiary. And renewal of a license, law is well settled that renewal of a license means a grant of license, new grant of license. এখন দিচ্ছি আমি।
Yes.
And his last license is also under 2013 Control Order. Therefore, the first question arises, can he challenge? Can he say? Can it lie well in his mouth? Or can a writ petition is maintainable when he says 2013 Control Order is redundant and he is beneficiary of the 2000 Control Order still now? আমি তো আর পারছি না তোদের নিয়ে আমি আর্গুমেন্ট করি না তোদের সঙ্গে কথা বলি কনফারেন্সও আসবে না কিছুই না 2003
Yes.
This is my first point. Now, my lord, you are saying that saving clause 2015 saving clause. Now, my lord, kindly come
to 28.
No. Page 200. It starts from page 227 that 2015 Control Order starts. Now, therefore, in exercises of the powers conferred by Section 3 to
228.
Now, my lord, kindly come to page. He is saying 228. Provided that provisions of the, kindly see, provisions of the Public Distribution System Control Order 2001 shall continue to have effect against the corresponding of this order in any state which has not implemented the food security or implementing the said act only in part. That part means Mr. Bandyopadhyay's argument, my lord, I will not repeat his argument. Now, my lord, kindly come to just 1 minute, my lord. Kindly come to page 261.
261.
Yes. Oh, sorry, later. 261 is another order. Kindly come to page 259. He has said saving provision. 2015 non-control order has saved me. Therefore, I can continue with the 2013 licenses. One of his argument was
show us the saving clause and then come.
Come to 259. What has been saved? 259.
Yes.
protection of an action taken under order. No suit, prosecution or other legal proceedings shall lie against any person for anything which is in good faith done or intended to be done in pursuance of this order. Now, 17. The central government may give such directions as it may deem necessary to the state government for execution of all or may of the provisions of the order. What is that directions? The central government may give such directions as it may deem necessary to the state government for execution of all or any of the provisions of this order. What is that direction?
Irrespective of that, the proviso operates.
No, Mulad, we have to read this a statute completely, not in an isolated manner.
But Mr. Bandyopadhyay, how will you overcome that proviso?
Which one?
This page 228.
Yes, I am coming.
That is dependent upon whether NFSC has come into if implemented or not implemented.
Right, yes, that part has been argued.
Yes.
Implemented, not in. I am saying.
So you are arguing.
If your lordship wishes, I can argue on that point, but it will be a repetition.
No, you are saying that over and above that, this clause.
Over and above clause 17 is there. Milord, for the purpose of making interpretation of a proviso, whether would your lordships can ignore clause 17?
Yes.
It's an interpretation of a statute. While interpreting any of the whole control order, whole statute, the court will take into note of each and every provisions of the statute. For upholding the provisions of the one portion of the statute, court cannot ignore another important provision,
But how does this help you?
Which one?
This 17.
Clause 17, I am saying that this is no direction.
No direction for what?
The central government may give such direction as it may deem necessary to the state government for execution of all or any of the provisions of this order.
That is 2015 order.
This is, I am reading from 2015.
Yes, 2015 order.
After this 2015 order, control order was made ready, clause 17 says, central government will give directions to execute the order to the state government. Central government has, this is the Ministry of Consumer Affairs have made this 2015 control order.
Yes.
They have made the provision of the proviso.
Yes, there is no such direction.
Where is that direction? They have shown to your lordships any directions. Showing the note 2015 control order, 2015 control order, 2015 control order. Ultimately, clause 17. Clause 17 says central government will give the directions to the state government. You execute the order. It is a subordinate legislation, Miller. I am having a subordinate legislation. No subordinate legislation can direct that you should make this another subordinate legislation. Who is the appropriate authority? Appropriate authority is the government. Under section 3, delegation power, section 5. That delegation power, this central government had not said, passed any order, you give effect to all the directions. Or some of the part or some of not the part. Where is that direction? If that, in the absence of that direction, can we say, no, only 2015 control order will do?
So your argument is, since there is no direction under section clause 17, you cannot say that the 2018 control order has
2013
control order
has gone. What?
So your argument is, in view of 17, 13 still exists.
13 exists, still it is existing. Sir, my lord, sorry, I don't mind. Both of the house, this is some, there I say my lord, here sometimes I say sir, don't mind, excuse me. Kindly, my lord, see, there cannot be any vacuum. All right, 2013 control order is no longer existing. In terms of 2015 control order, there is no control order has been framed by at the time of moving of this. Today it has been made, that is again challenged. by them.
That is of
Another matter, 2024.
24. Yes.
That we are not concerned about this. 2015 control order, state has not passed any control order at the time of moving. Would there be a gap?
Yes.
Limbo? If his argument is accepted, then all over West Bengal there should not be any distribution system. Neither he can distribute nor anyone can distribute.
Yes.
And for that, Mr. Bandyopadhyay has also, Sishwano Bandyopadhyay has already cited one judgment. Now, Milord, kindly come to see page 260. Kindly come to page 260.
Yes.
See, this is a rule. In necessary powers conferred by food security, the central government, after consulting with the state government, hereby makes the following rules. Central government has framed the rules. August 2015.
Yes.
Kindly come to 61 clause 5. See, it shall be the duty of the state government to take delivery of food grains under targeted public distribution for the designated depots, ensures its delivery through their authorized agent up to the doorstep of fair price shops and to ensure its supply. Therefore, who will withdraw? State government itself, not distributor. If his argument is correct, he is no longer there. He is a distributor. He is not state government.
He doesn't mind that. He said that I will go, but it should be in accordance with law.
Very nice. If it is done every cases, there is no difficulty.
No, that here we have put this question to him. He says that yes, I am not worried. I will be affected.
But I have no difficulties. I am saying. I have no difficulties. I have just newly born baby.
Yes.
Not yet tested the mango of this season. And he has tested the mangoes of 30 years.
That is the hard part.
Therefore, I have not got the taste. He has got the taste. Let him remain with without taste.
Yes.
I have no difficulties. If it is implemented, the state government will answer. Therefore, what I am saying, if the 2015 control order has not been given effect to, rule is also not given effect to. My submission would be irrespective of the fact, it doesn't lie. If his stand is correct, then he is not there.
Yes, he is not there.
He is not there. In Bengali, there is a proverb, Nijer naak kete. Affidavit, no, if it is goes.
No,
I am happy.
That we have accepted that. There is no wavering from that. He has specifically said that yes, I will go.
No, where is that petition in the Abarment? There is statement from the bar. Statement from the bar.
No, are you saying that this must be put on evidence?
Yes.
Why? He is arguing.
No, he is arguing. It is an argument. This is a factual position. Whether they are happy or not happy.
That is immaterial. If we hold against them, what is
that is different thing.
Yes, next.
Now, your lordships have observed that he has said if it goes, everything goes.
That is what is happening.
Now, this is so far license, etc., I have shown to your lordships. Now, kindly national security part.
Yes.
National Security Act part has been argued by Mr. Sishwano Bandyopadhyay. I am not. I will be arguing the points now. Kindly see prayer. What was his prayer? at page 44. Kindly come to page 44. It is in the matter of commanded respect after vacancy, the matter of subsequent subdivision so and so, dated 3rd June to the read with order number so and so issued by the government of West Bengal so and so. There is so and so vacancy declared, these are being set aside. Is there any prior declaration that the 2013 control order is redundant or declared to be null and void or illegal? Alternative to the 2015 control order? Is there any prior?
Yes.
Whether now, therefore, whether this honorable court will make an inquiry into the fact whether 2013 on control order is good or bad when such a prayer was not made.
Yes.
He is saying redundant means what? Ultravirus to the 2015 control order. Therefore, 2013 control order cannot be given effect to. This is redundant is a different thing. In the law, redundant is a general word. In the law, ultravirus. What is this prayer? Can he asking something beyond the prayer?
Yes.
Now, beyond the prayer, he is asking. Now, my Lord, kindly see. ছেড়ে দেবো, ওটা তো অন্য কিছু। আর আমার ওই জাজমেন্ট এটা কোথায়? একটা বই দাও, জাজমেন্ট জজ সাহেবকে দাও। It's 311 once. Finally, come to page 311. See, 2013 control order was amended in 2022. Notification টা কোথায়? Vacancy. Vacancy notification date টা কবে? Huh?
Yes.
My Lord, kindly see, date is April 12, 2022.
Yes.
Notification was 1st September 2022 for vacancy. On the basis of the amended provisions.
Yes.
This has also not been challenged.
So what did the trial judge say as regards? What did the trial judge say as regards this argument?
No, trial judge has held that only the Food Security Act has not been implemented, therefore it is bad. So far, my appropriate and reprobate question, trial judge said, no, I will not go into the question since I have held that the NSFA has been not been implemented, therefore. Therefore, 2022 control order has not been amended. Control order has not been challenged by him. Although September 2022 vacancy notification was issued. Now, my lord, kindly take, my lord, 1997 1 SCC page 650 এটা 70 দিয়েছে এটা তুই কি 70 টা নিয়ে পড়ে রইলি 1997 টা বললাম কি দিয়েছে 70 all right 1976 which give it 1976 3 SCC 334 kindly that's a different point I am coming 334 sorry Miller 575 sorry 575 575 কোন প্যারাগ্রাফ 8 and
yes
প্যারাগ্রাফ 8 and 9 তো কিছু নেই 575 আছে কোনখানটা পড়বো আমি কোনটা পড়বো কিসের জন্য পড়বো এটা লোকাস্ট্যান্ডে নয় ভাই না আমাকে মতো করে কেস করতে দিবি না তুই একদম মানে কাইন্ডলি এক্সকিউজ মি ফর দি টাইমিং কাইন্ডলি কিপ ইট আমার মতো করে আমাকে কেস করতে তুই দিবি না একদম মানে কাইন্ডলি টেক 1997 1 SCC page 650 মাথাতে ঢুকে থাকে ব্যাস ওটা নিয়ে ডুবলি kindly see Miller 1997 1 SCC page 650 kindly come to Miller paragraph মিলছে না তো kindly come to paragraph 25 then kindly come to paragraph 25 is not important kindly come to paragraph 36
yes page
paragraph just 1 minute Miller. Paragraph 36 yes in P Ramannath as the law lexicon
paragraph
36 paragraph 36
yes
in P Ramannath the law lexicon the word renewal is defined at page paragraph 1107 to mean a change of something old for something new. The renewal of a license means a new license granted by way of a renewal. The renewal of a negotiable bill or notice regulated simply so and so. 37. In Purvas Chandra Dalvi versus Vishwanath Banerjee, this court drew the distinction between the meaning of the words extension of and renewal. A distinction between extension and renewal is chiefly
that in the case of a renewal, new license is required, while in the case of an extension, the same lease continues in force. Therefore, what I was submitting, every renewal means every license has been granted. 1981 205.
So how does that if every renewal is a fresh license, their license has also be application for renewal will be under the
2013 control order. Therefore, he is enjoying a license today under the 2013 control order.
Yes.
Dana, jat korish na. Just give me 1 minute.
This article Bandyopadhyay is that as every renewal has to be treated as a fresh license, if 2013 is said to be ultra virus today, then his right to get a renewal of that license will also go.
My submission is, that's the second part. My submission is, enjoying a benefit of a 2013 control order, you cannot challenge.
You cannot come and say that.
No, that is bad. You cannot approve it and reprove it. That judgment I will just cite.
Yes.
My lord, kindly come. Kindly down. 1981 2 SCC 205. Similar paragraph 11. Kindly come to. It's a big paragraph. At page 218, kindly come. My lord, in the middle. Yes. It starts from paragraph 11, but kindly come to 218. It's a big paragraph. Only 2 lines I want. So to 218, just in middle portion, a statutory rule. From the left hand side, it starts. Lots of got it. First, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th, 12th, 13th, 14th, 15th, 16th, 17th, 19th, 20th, 21st, 22nd. 22nd, my lord. See, Rule 8C has been made by the state government by notification in the official gazette pursuant to the powers conferred on 59. A statutory rule will ever subordinate to the parent statute is otherwise to be treated as a part of statute and as effective.
Yes.
Then see, rules made under this statute must be treated for all purposes of construction or obligation exactly as if they are in the act and are to be the same effect as if contained in the act and to be judicially noticed for all purposes of construction of obligation. Therefore, 2000 control order, which is subordinate legislation, is a part of the Essential Commodities Act. A part of a statute.
2013
control order.
Is a part of section, is a part of the statute.
Statute, because of under section 5, power delegated rules have been framed. My lord, my point is whether 2001 control order is there or not, 2001 control order is there, exists or doesn't exist. I enjoy independent power to, I mean state enjoy independent power in view of section 3 and section 5 to legislate this subordinate legislation. My power to legislate subordinate legislation does not flow from the 2001 control order. It is an independent power.
Yes.
Is it a subordinate legislation or not? Therefore, kindly just see now, my lord, I am just making, my lord, kindly just
Visualize the position. 2015 control order, framed, clause 17 says central government will give the direction to pass a control order. The moment central government will pass the direct under clause 17, which I have shown to your lordship, then the compulsion is coming to the state government to make.
Yes.
It is a part of central government can modify. Easy. I have no problem. The central government says. But the 2015 control order clause 17 has made it very clear when the central government will direct. Therefore, rest of 17, if you read 2015 1 to 16, that cannot supersede my power. Only when 17 will come, that supersedes my power. I mean, my power means here state power.
Yes.
79 1 stage into them.
But this is a independent stat which you are saying 2013 control order is an independent product.
Yes.
Of section 3 read with section 5. That has no relevance with regard to 2015
control order.
But that has been held against you by the single judge.
Single judge has held it, but we have
you have not preferred appeal against
cross appeal.
You have preferred cross
appeal. Yes. But irrespective of the fact, cross appeal is there or not, Mr. Shishano Bandyopadhyay has argued before your lordship.
That is another.
Yes.
Irrespective of that, I can challenge. Yes.
Cross appeal. I have cross appeal, including this one. Including this, I adopt Mr. Bandyopadhyay, Shishano Bandyopadhyay. But now, see, this is kindly take 1979. Amar copy koi. Nee.
Yes, 1979.
I mean, really parvo na.
One copy. You give us one copy.
No.
Share it. We will share it. No problem.
1979 1 Calcutta High Court Notes 504. This is one of the Justice Omio Mukherjee. Similar, both 1964 control order, rationing order, and 1967 paddy licensing order are pieces of delegated legislation under the essential
paragraph here.
Paragraph 28. My lord, kindly take this, please.
No. We have got paragraph 28.
Yes.
Yes, both
1964 rationing order and 1967 paddy licensing order are pieces of delegated legislation under the Essential Commodities Act 1955. It is well settled that once the executive exercise the power of delegated legislation, the same become a part of statute. The essential legislative function is the determination of the legislative policy and formation rule of conduct, so and so. Therefore, this is a part of statute. Rather importantly, point would be before your lordships to consider whether a subordinate legislation can
override the power conferred by
and can make it defunct of the another subordinate legislation.
But that is of central. It is of state.
Maybe central or state. See, my lord, let me tell your lordships. Excepting under Article 136, is the High Court is subordinate to the Supreme Court? Law is settled.
Yes, sir.
There is no. He said, we are in a federal structure. This is a power.
142 power, Mr. Bandyopadhyay.
That's a constitutional power. You are not subordinate. I am saying that excepting under Article 136. This is a law, settled law. And administrative capacity is a different thing. But Now, is the assembly is lower status than the parliament? No. These are the questions. These are not the political, these are the constitutional questions. Everywhere arena is fixed. They are working in the arena. That doesn't mean one is another one subordinate. 7th schedule of the constitution lists, it is not a political, it's a constitutional.
Yes.
Only when a clause 17 order is there, central government will say you do it this, only it comes in. There is a part of an executive order, what I am submitting to your lordships. Now, my lord, next point is approbate and reprobate. My lord, approbate and reprobate. My lord, 2020, 2022, till 2022, 22 volume 2 SCC page 25. Kindly come to paragraph 26.
Para 26, yes.
The phrase and the borrowed,
yes.
The phrases and borrowed from the Scots law, they would only mean that no party can be allowed to accept and reject the same thing, and thus one cannot blow hot and cold. The principle behind the doctrine of election is inbuilt in the concept of approbate and reprobate. Paragraph 26, my lord. Concept of approbate, once again, it is a principle of equity coming under the contours of common law. Therefore, he who knows that if he objects to an instrument, he will not get the benefit he wants, cannot be allowed to do while enjoying the fruits. One cannot take advantage of one part while rejecting the rest. A person cannot be allowed to have the benefit of an instrument while questioning the same. Such a party either has to affirm or disaffirm the transactions. This principle has to be applied with more vigor as a common law principle. If such a party actually enjoys the one part fully and on near completion of the said enjoyment, thereafter questions the other part, an element of fair play is inbuilt in this principle. It is also a species of stopple dealing with the conduct of a party. We have already dealt with the provisions of the Swanso. No. License, I will benefit. Today is also saying allotment. That's also come from 2013 control order.
Yes.
Therefore, this part I will accept. It will be in my favor. But when it will be applicable to others, it is bad. Milord, this is not accepted provision. Milord, kindly see, excuse me for a moment, Milord. Such a party as this one, the principle is after with more vigor. Is a party enjoy the one part fully and on the comes there are the questions about an element. See, sorry, Milord, 26 page 38 last sentence. A person cannot be allowed to have the benefit of instrument while questioning the same. He cannot. Today he cannot question. Another one judgment on this point. That's 2023 6 SCC page 401. আমাদের পসিবলের নাম্বারটা বলে দিন 2023 6 SCC page 4 9 মিলা ওখানে কি হলো রে কেউ তো খবরই দেন ওখানে কি হলো অর্ডারটা কি অ্যাপল করলো নাকি না কিছু চিন্টু করেছে তো সরি ম্যাডাম এক্সকিউজ মি হ্যাঁ ভরতসেন দেখেছেন? ভরতসেন দেখেছেন?
The doctrine
Today
of
I am a very bad today I am in a very bad situation. Especially after 2 p.m. That's the reason in the morning I came, give me 15 minutes. And Lordship was so nice. 29.9, 4 to 4. Same principle, 29.9.
yes,
The doctrine of election is inbuilt, the concept of approbate and reprobate. One cannot take advantage of one part while rejecting the rest. A party cannot be allowed to have the benefit of instrument while questioning is at the same time. আর কি আছে? এই তো। Standing में कुछ प्राइस का क्या पड़ता है? Paragraph 7 তার লেখা ছিল। Threshold at the first judgment, I handed it over to your lordship, but I didn't say. 1970, 1 SCC, page 575.
yes, earlier you gave it to us.
First judgment, but I did not rely at that point of time.
Yes, yes.
Very small judgment, my lord.
Yes. 1970, volume 1 SCC.
Page 575.
Uh.
Kindly come to paragraph 9. This is, my lord, the Nagar rice and flour mills and others versus N. Tikappa, Gowda and brothers and others. Kindly similar. Paragraph 9, my lord.
Yes.
Section 8, subsection 3C is merely regulatory. If it is not complied with, the appellants may probably be exposed to a penalty, but a competition in the business cannot seek to prevent the appellants from exercising the right to carry on business because of the default, nor can the rice mill of the appellants be regarded as a new rice mill. Competition in the trade or business may be subject to such restrictions as are permissible and are imposed by the state by law enacted in the interest of the general public under Article 19, subsection 6. But a person cannot claim independently of such restrictions that another person shall not carry on business or trade so as to affect his trade or business. His case was that, no? If it is granted, I will be affected. Vacancy was challenged.
You will be affected.
He will be affected. I am not. He is the writ petitioner.
No, 2013 beneficiary.
Huh.
He says that if it is that argument you made before us.
Oh, yes.
Sorry, I didn't get the last line what you submitted. Just now you submitted, yes. That he will be, you will be
There's
this
a
benefit
permission
of
imposed by the, but a person cannot claim independently of such restrictions that another person shall not carry on business or so as to affect his trade or business adversely. His case is that I should not be allowed. He said I should not be allowed.
Yes.
He is challenging the vacancy notification in the writ petition itself. He wants that he should remain, no one can come because his trade and business will affect it. That is the pith and substance of the matter. Leave aside all these legal arguments, technical things, legal things. But what is the main thing? We have to go to the main substance. What he is asking for? He is asking that nobody should come. I should only remain in this trade. That is the gist of the thing. That is the gist of the matter. This is illegal, this is unconstitutional, this is it's all right. All should be set aside. I should remain only. Because I am affected. He said today in the original said matter, I am affected. 8 have been taken away. I am affected. See, another person shall not carry on trade as to affect his trade or business adversely. The appellant complied with the statutory requirement of carrying on rice and milling operation in the middle of the. Even assuming that no previous permission was obtained, the respondents would have no locus standi for challenging the grant of the permission because no right vested in the respondent was infringed. What is right has been infringed? Grows up, basically when it not matter. When sons grows up, especially in our field, it creates a great help to father.
Yes, nothing like that. We are happy to learn that you are happy for that.
Yes, I am. I feel proud for my sons and daughters.
Yes.
I was stuck up here. I told him within a few 4 minutes, this is the matter, this is the point, this is the point. Did it? Wavelength is. And at the old age, the grandsons and granddaughters are the most favorite to us. And sons and daughters are the real, we have to.
Principal and interest.
Yes, be it. Madam, can you see page 46 of the petition? What he is asking for?
Page
46, prayer, injunction prayer.
ঠিক আছে রে বাবা। আমি কি ছোট করে প্রশ্ন করতে হবে না সেরকম ছাড়া
Petitioners name are distributors.
Page 44.
46.
46.
H, sorry, prayer H, page 46. Prayer H, page 46.
Yes, from delinking.
This is his main interest. After this all constitutional, etc., my lord, ultimately, what is the object? What is the substance? What is the object he wants to achieve? He wants to achieve that nobody should remain here, I only. Only in this state, the persons who are carrying on the distributorships, only they would remain, no other new people will come. No vacancy would be created, no other vacancies would be created, we would only remain. That is his main object. And years after years,
The moment I will go to the original side matter, your lordship will, I will tell your lordship the fact. 6 years it is continuing. Showing this order here, this order there, this order here. He is not a party to any matter. I will show your lordship.
Yes.
And whether your lordship will consider, when I will place the original side matter on the fact, your lordship will consider whether this court will indulge these types of litigants to approach or not. Very serious things. This is the appellate. Yes. My lord, your lordship wanted to see the order which was passed by my lord Justice Division Bench on 6th August 2024 in this matter.
Yes, 6th August.
না তারপরে যেগুলো হয়েছিল বলে দিল যে this is only applicable here, ওগুলো কই দাও, ওগুলো দাও। See,
No, in
the list of the appellant, he is
which one you are referring to?
the order.
Date?
Date is 8th August, 6th August 2024.
6th August 24. এটা কি অ্যাপেলেট সাইডেরটা দিয়েছো?
Appellate side.
6th August 24 order.
No, appellate side. 6th August 2024. ये ना আমাকে একটা কপি বার করতে হবে রাহুল। তুই তো কিছুই জানিস না রে, তুই তো যে বেড়া দিয়ে আরে তারপর তো জজ বলে দিল, জজ স্যার ক্লারিফাই করে দিল সবগুলো। দে না একটু কপি দে না, কপিটা আমি কিছুই নিয়ে আসি। My lord, kindly take this one.
Just a minute.
My lord, got it, miss? বড় বাজারের দোকান চলছে, ভালো চলবে তো। আমি বলছি তুই বড় বাজারের দোকান কর। আগে
6th August.
6th August, ঠিক। See,
এটা তুমি পাবে না।
paragraph 10 kindly read. See, we direct none of the ration card holders shall be dealing from the dealers, and the dealers shall not be dealing from the distributors if not already done for a period of 2 weeks from date until further orders whichever is earlier. And in our case here, delinking was made.
That is 12th February 2025.
No, that's a different matter.
Oh, acha. This in
Here, in this appeal. In this appeal.
That protection was for 2 weeks.
Thereafter extended. Therefore, if the appellants, we were the respondents in this matter. If the delinking has not been made, that will continue. If it has not been made, delinking has been made in these appeals.
Which appeal? There are independent appeals.
Appeal which I am arguing before the Lord. Sitara Begum. Yes, I am not for the others. I am arguing the Sitara Begum's case.
So in Setara, delinking was done.
Yes.
Where do we get that?
We are getting the benefit we are getting the benefits because, see, my lord, this is their cases also. They have said single judge dismissed the petition on 1st August. Licenses were granted to us. Goods have been allocated to us. Delinking has been made. This order has been passed on 6th August. In between 1st August and 6th August, this development had been taken place.
Yes.
There was delinking was done in these our cases. We are running this up. Now, point is, why I am saying that will not helpful for the original side matter. These orders are applicable to the appellants and respondents in the matter.
What is intention?
Original side appellant was not the appellant in this appellate side. Therefore, extension of this order in his writ petition doesn't arise at all. This has been made.
No, but his argument was, forget about.
I am coming. Just, your lordships have heard one side. Just wait. They did not say to your lordships that they have filed an application for interim order in view at the strength of the Justice Joymallo Bagchi's order, which is pending. If the interim order was existing in his favor, why did he made the application for imposition of a new interim order since the other interim order has expired? I will show.
Yes.
One of the fraud has been committed. I'll show. Therefore, why? Now, my lord, kindly see another order, 21st February 2025.
Mr. Bandyopadhyay, we are hearing the main appeal, irrespective of interim order. What we are deciding today, whether they will.
I am just clarifying. My lord, if your lordship wants to hear me in the original side matter as a respondent, I have to show your lordship the facts. It is not correct what has been submitted to your lordships.
Yes, we are.
When I am saying with responsibility, I am saying I have did the matter. If one says I have suppressed a fact, he is liar before this court. Great liar. I will show from the order itself.
All right.
44 years I am not here cutting grasses.
So your argument so far is this appeal?
I have never argued a matter. If I know this is the matter is there, this is the order have been passed. Whether my junior stays or junior doesn't. I do not argue any matter on the point of law as per instruction of the clients or as per instruction of this. To me, not like Mr. Devabrata Saharai. My lord, I object it. What I have said. Don't allow my learned senior friend to me, not like not like Dr.
Yes.
Kindly come to paragraph 6
Paragraph?
of that order.
Paragraph 6, yes.
Mr. Bandyopadhyay, learned senior counsel, 6, leave to appeal. He contends learned single judge misconstrued the order passed in Sitara Begum versus State of West Bengal and others and held that the order of status quo in respect of delinking is not restricted to the appellants but extends to all dealers in the State of West Bengal. Incorrectly interpreting the order as aforesaid, the Honorable Judge extended relief to the North. In rebuttal, counsel for the respondent submits the order of injunction has been passed on the premise. Similar issues are pending for consideration before the division in Sitara Begum. Now let's see. We have given our anxious consideration of the content of Mr. He is correct that the order of status quo passed in Sitara Begum is not an order
in rem and does not apply to other dealers. It applies to the appellants before this court. However, the impugned injunction is not only on the ground that the status quo in status Begum is applicable to all dealers. Honorable single judge rightly observed that it might create multiplicity of the proceeding in order of status quo is not passed, restraint delinquent of the and akin to the interim order passed as similar orders are falling for decision in Sitara Begum as well as the writ petition before the honorable single. They were clarified, although no clarification was required in judge division. The interim order which I have shown to your lordship 25th, when it came to the extension, the judges have passed the order of status. Therefore, the status quo order was applicable to only the appellants or beyond the appellants. Whoever may be 125. Big racket is going on, 125.
Yes.
All petitions are pending. No one will come. We have made a syndicate, we will do it. ক্ষমতা আছে কি Okay, 2 p.m. 2 p.m. I have another one matter has been fixed at 2 p.m.
28.
20 Monday. No problem. Can I argue at 3 p.m. or just I will finish and I will come?
No, we will give him chance to reply and conclude the hearing.
No, original side I have to argue or not argue. If I am not to argue, then I will not come.
No, original side matter we will. You have to argue now because otherwise.
Therefore, let him. I will not be able to at 2 p.m. My lord. Just I say to your lord. 2 p.m. is fixed.
Mr. Bandyopadhyay, what we are suggesting is let Mr. Shaharai give the reply in the appellate side matter at 2 p.m.
No, that will be continuing. Kindly keep it at instead of 2 p.m. Kindly keep it at 3 p.m. I will finish my original side argument.
Then again we have to give him time.
Yes, lordship will give him 28 3 p.m. My lord, I 2 p.m. I'm take it in the morning. I don't know how the difficulties.
So, Mr. Shaharai, as so far as the original side matter is, do you want us to record this fact or we leave it as it is? Because
not record.
Not required. And another thing, Mr. Shaharai, because when you were absent, an argument was being advanced that this 2013 circular which you are saying is redundant would be
Sir, can I
affecting.
go, Millard? Yes, I have a man. Very important matter has been taken. Just excuse me.
Yes, then when do we keep it?
Tomorrow, 28th morning.
Morning or not? Then 28th we keep it at 3 p.m.
3 p.m. No problem.
And
Give
Mr.
luck.
Sarai,
Well, just
you
excuse
will
me.
take 15 minutes, not more than that.
No, 15 to 20 minutes, not more than that. I can assure to your lordship.
Item 25, we have taken up an application for addition of party. 25 addition of party? What?
Item 25, the license was granted by Tiber Malak.
No, we are keeping it. We are.
Your lordship is asking one question to me.
No. Just wanted to. Your junior was there, but still because Mr. Bandyopadhyay submitted that this circular which 2013, if it becomes redundant, then it will be affecting your rights also. So then I told him that I have basically we have specifically questioned this to Mr. Sarai, and he said that that does not affect you in any matter. If it becomes redundant,
Saving clause.
No, but he's saying, but there is no affidavit on record to that effect that this may happen, because this we wanted to inform you. Now it is up to you to decide. Your argument was that as per the saving clause, you will continue.
Yes.
That's
the observation of the learned single judge. That is the observation of the other division bench. I shall show to your lordship.
Very good. Then
It
we are
says
not
if-
adding.
If any right acquired.
Very good. We are
Appeal
not adding. We are not adding any observation in respect of the original side matter.
Because your lordship is
Original
keeping the
side
matter quiet.
সোমবার দিনকে 3টের সময় রেখে দিন।
My lord, only thing, my lord, kindly give me.
Are the learned advocates
Or any day, subsequent to 28, any day, half an hour.
My lord,
No, we don't know how many matters are going to be tagged in with our matter. 3 matters have
Only
been
one
mentioned
judgment will
today.
cover everything.
everything.
Single judgment will cover all job matters.
কত তারিখ বললে? Then you inform Mr. Bandyopadhyay, we are keeping it on 7th May then. 7th May at 2 p.m.
আগে জেনে নেই।
No, please. Sir, you please 7th May will be available. Then again another problem will arise.
Or in the appellate side matter, intimator is going to be expired on 30th. Appellate side matter.
আচ্ছা তাহলে ওই সোমবার 3টের সময় রেখে দাও।
My lord,
On Monday আর ওইটার সাথে ওই নতুন অ্যাপেলেট সাইড ম্যাটার অ্যাপ্লিকেশন যা
item number 38, 39 is concerned. Only point of law.
yes You have given the numbers.
appearing as identity can in connection to item 25.
You remind us next day. Sorry to find. এটার সাথে ঢুকিয়ে দাও।